Well, good evening for those of you catching live and to those of you on replay. Happy day 8 of trial. So, for those of you guys catching this stream for the first time, we're covering the case of Kowalski versus Johns Hopkins All Children's Hospital. This is a case that involves allegations and, well, events that occurred that were documented in the Netflix documentary, Take Care of Maya. Some of the information we're discussing tonight is sensitive in nature in that we're discussing issues involving a minor that was being treated for CRPS when the hospital, based on the plaintiffs, alleged that the child was instead Munchausen's by proxy. Like I said, some of the allegations are relatively sensitive in nature. So I do put a little ticker up at the bottom so that people, when they come in and watch, they know what they're watching. Not trying to mislead anybody. We have a lot to cover. There's a lot of sensitive topics, and we begin with a very sensitive topic in today's proceedings that I'll try to break down and summarize the best I can. I do want to mention really quickly, because there were some people that were very generous before the stream started. Gifted memberships by Dawn Burke last night after I had ended the stream, gifted 20 memberships. Ryan Man YYC is gifting memberships already. Leila Quinones is gifted 10 memberships. Fiona, 10 memberships. And Emma has gifted 50 memberships. Pamela Weisenbach, 10 memberships, and Golden Girl, 5 memberships. You guys are all absolutely amazing, and thank you for helping to grow the channel. I've been doing these recaps. I am a full-time practicing lawyer. For those of you wondering why we're listening to somebody talk about this case, I'm a full-time practicing domestic relations litigation attorney in Northern Virginia. So this case has a remarkable amount of overlap to cases that I cover, cases that I try in courts throughout Northern Virginia. So I found it interesting to both cover this trial and then explain it to the best I can at the end of the day, recapping some of the things that we've heard throughout the day for those of you who are interested, because there's a lot. It's a really complicated case. And as we're going to hear later in the testimony and in some of the motions argument, I've made the comment that the plaintiffs are dancing a tightrope. It's a tightrope, and all the attorneys are doing their very best. I can tell you this as a kind of a precursor to today. I do not envy the attorneys in this case on either side. You're going to hear later today later this evening rather, that there are, I think, 52 orders on the motions for summary judgment. So 52 orders on summary judgment motions, which lays out the constraints of what you can and cannot argue. That is to me, that's unheard of. And the attorneys are having to navigate this with their witnesses as they go through it. But at the beginning of the day, we had, actually, let me throw this banner up so that people aren't surprised. At the beginning of the day, we had an argument over what I think the judge has called newly discovered evidence. And the plaintiffs have sought relief from the court. Right now, the plaintiffs are on their 8th amended complaint. They have alleged various causes of action against the hospital, intentional infliction of emotional distress, battery, as well as false imprisonment claims. They're on their 8th amended complaint. This is a case that's been going on for several years in front of the same judge. And during the trial, after the jury was impaneled, the plaintiffs brought new information to light that Maya Kowalski had reported to them, that what was alleged in the complaint went further. What was alleged in the complaint was that my apologies, Ms. Beatty had been alleged to have committed an unwanted touching, a physical battery that had sexual undertones. And Maya elaborated during the trial to her plaintiff, or to her counsel, that this actually went further than that it actually involved a third party in the office, in the hospital staff. A male doctor entered the room, requested that she disrobe, photographed her in a state of being disrobed, and that should be added to the complaint at this stage. Back and forth argument. They have both pled the issue. They have both filed motions on the issue. And what we're going to start with today is kind of the judge's ruling on that. This is an issue that is very sensitive and, well, very tough from a procedural standpoint, because both of the parties have rights proceeding with this. The plaintiff has the right to bring the claims. The defendant has the right to know the claims that are being brought. And that awareness comes first and foremost from the pleadings. The pleadings set the framework within which we operate. So the trial is constrained to the pleadings. You can't go outside the pleadings. You can't bring in information, evidence that's outside the pleadings. And if you don't notify the other side formally in the pleadings, then they don't have the ability to respond to it. This is a little bit different than in cases of that we've covered on this channel and others, criminal cases where they discover evidence during trial and they bring it in. This is different. This is a new claim. It's unique. So essentially, it would mean going back to square one if they were not allowed to bring this in the middle of trial. But from the defendant's standpoint, this means that after a jury is impaneled, a jury that did not get questions of this nature, and after opening statements where they didn't get to address the issue, we're trying to bring this up now. So I see both sides on this one, and it's a tough call. So we are going to start with where the judge begins today after doing some evidence stuff. Go figure, evidence stuff with that particular motion. As an FYI, today we anticipated that Jack Kowalski, Maya's father, would remain on the stand after finishing yesterday, and that would take maybe an hour of court time. We were wrong. Jack Kowalski took the entire day. So Jack Kowalski is on the stand for the entire day, broken up by motions that argue anywhere from 30 to 45 minutes. I'm going to try and speed through the motions mostly because I think that's some of the most pertinent stuff. The testimony I'll try to summarize based on my notes. That's just a little bit of a warning of where we're going with this. So without further ado, let's go ahead and, well, let's go ahead and bring up, look, just so that people know what we're talking about. Oh, look at that. Motions and argument. Let's get into it, folks. Let's get into it. Let's see what's going on in this courtroom. Share the screen. For those of you wondering, the volume is gained up 600%. So I can't make the volume any louder. And for those of you wondering why I was late today, because I was watching Law and Crimes feed. I like Law and Crimes feed because it's a full day feed. It doesn't break it up. Tampa 13 has been covering it, but they break it up from morning to afternoon. And Tampa 13 misses some of the motions arguments. I think the motions arguments are really important. So I've been using the Law and Crime stream. That said, Law and Crime stream right now, when I pull it up, shows this being 30 seconds long. So all the timestamps, everything that I had, all the notes gone because the stream decided it wanted to be funky. So please bear with me. Today is going to be a shorter day. I do have an early day tomorrow. I have an appearance at 9 a.m. So that means that I can't be doing a 3-hour stream tonight. So for those of you guys thinking that I can dance through a lot of this and go through all the testimony, I just don't have the time. I'm trying to do recaps and give you guys the punches, the highlights of the day. So again, thank you for being here. If you are here, please hit the like button. Also, please subscribe if you enjoy some of this stuff. Well, the recaps rather. So let's get into it.
In response to the parties wish to add any further argument.
On behalf of plaintiff, Your Honor, there is no signs or indications, and nor would I as an officer of the court ever misrepresent my knowledge of this. It is a well-known psychological phenomenon. The court's familiar with that children often suppress these things. It was revealed in two ways. One to Dr. Katzenstein, and now I learned there's a similar.
We're beginning the day on a good foot. Muted, Rob. You're muted. You're muted. Elaine, your microphone. Elaine, your microphone. Elaine, your microphone. Oh, okay. I was telling people that we're speeding this up to 1.5 times. I have found that 1.5 times speed is about that magical zone of chipmunk where you can still hear what's going on, but we don't have to listen to the pauses that long, and we get the information in a digestible format. This trial went for 8 hours today, 7.5 hours. I can't do 7.5 hours of recap. It's just not possible. I wish I could cover this trial live while we're watching it, but I can't. Like I said, full-time practicing lawyer. So my apologies for both the muting and for the speeding up, but you guys can slow it down if you need to.
Type of comment in the
Let me know if you can hear.
Jackie Henschke records. As soon as we knew about it, we did the right thing, which was to confirm before we raised something like that there was confirmatory testimony and knowledge, which we did with Jack Bertram. In this instance, I think the goal should be the truth, and the jury should have all of the information. This case has been about Maya being assaulted or battered since the very start of it, and there have been allegations raised. I would point out, Your Honor, that upon receipt of the response, we did the timing upon receipt of the response to our subpoena ducis tecum for the Henschke records. The defense began from our notes, really pushing in earnest for any mention of sexual misconduct to be excluded. And I'd like to know from counsel whether they had identified something that I candidly did not, because I didn't even expect to call her, if the court recalls. But I'd like to know from them whether they had spotted back in response to subpoena ducis tecum those notations as well. I have the belief, although I'm not accusing counsel of anything, but I have the belief that their knowledge was far earlier than this. And the hope was that Maya would keep it in, or that we wouldn't notice some of these notations, which admittedly are oblique in some circumstances, though Henschke's is much clearer. And so if in fact they had this knowledge from the ducis tecum and otherwise, then they had advance notice of this. And the fact that they have pursued so aggressively, excluding any type of reference whatsoever with Beatty as the focus, is curious to me. In this instance, I would think that if you need, we've got the Katzenstein record is already in as a joint exhibit. So there is some evidence within the record without objection to that. So in this instance, having Maya Kowalski expand on what we already know, which is her belief that some of the actions of Kathy Beatty were of a unusual nature towards her, we believe that there was more than adequate notice and that it should go in. Typically, the final thing I'll say is typically in trials, new facts come up in every big trial. And typically the pleadings collapse into the proof at trial because it's impossible to plead every single fact in the complaint, nor even in an ultimate fact pleading state is it required to plead every fact. So we would move the court pursuant to our motion to allow that in.
Judge, I'm only going to address the comment about the accusation regarding the defense attempts to remove the spurious allegation of sexual abuse by Kathy Beatty, since I was the one that was addressing that. The only allegations in the complaint regarding any type of quote sexual battery and quote were against Kathy Beatty as her former counsel when she was a member of this case. I immediately began trying to address that because there were no factual allegations to support that anything Kathy Beatty did was of any type of sexual connotation. And that was the basis for all of those motions to try to get that stricken, which the court granted as far as motion in limine in regard to those type of unfounded accusations regarding Kathy Beatty.
And the motion, Your Honor, is basically a motion on an issue of law, whether they're entitled to bring this up in a situation where they have already admitted they didn't plead this. In the effort to try to specify better what the false imprisonment claim was and what the battery claim was, they've laid it out in their battery claim deals with Ms. Beatty in various places in the hospital and with other nurses and social workers in and around the 2-day period involving the EEG room. That's the battery that we came here prepared to try as a matter of due process. And now they're wanting to bring this in. The notion that they can bring this in as something under Rule 1.19.190B, this has not been tried already by express or implied consent. And this is otherwise something that simply cannot be brought up at this time on these pleadings. So if you have additional questions about what we've submitted, that's fine. I don't think we need to go into the facts, but I know that Dr. Katzenstein has a very different explanation for her note.
The court has before, Mr. Anderson, we can say something else.
Typically, we're talking about one incident here, Your Honor, and typically this is handled through cross-examination by pointing out that some of the incidents that the plaintiff testifies to in trial are different than those in the deposition, and they're impeached on that basis, if that ends up being the case. I would finally point out that the Katzenstein records went in without objection. And if we are in fact true, if our allegations are true, then there was no objection, and that allegation went in without any effort to clarify that or otherwise. So there's no prejudice here if, and as it appears from at least 2 independent sources of records, that there was any true prejudice.
The court has before plaintiff's motion to admit newly discovered evidence or alternatively to amend the complaint, which is at docket identification number or DIN 3444. The response actually was docketed before at DIN 3443. That has to do with how the clerk docketed when those were filed over the weekend. The genesis of plaintiff's motion has to do with what is clearly a late disclosure by Maya Kowalski. That disclosure became known to the court and to the defense counsel during the trial. That was after the jury had already been sworn. We had already conducted oral argument, opening statements, and started with witnesses. The court will assume, for the sake of ruling on this motion, that Maya Kowalski's statements are correct, that there was some type of sexual incident that occurred while she was at Johns Hopkins All Children's Hospital in October. The question is, given where we are right now in this trial, what are we able to do, if anything, about it? The plaintiffs reference the Binger case, but Binger really is talking about undisclosed witnesses, not an amendment to add new claims. We also have a rule that allows for pleadings to be amended for items that were tried by express or implied consent. Clearly, the defendants are objecting to try an issue that was not part of the pleadings, and it clearly was not part of the pleadings. So we get down to a final issue, which is notice. The whole point of having the pleadings is to explain the conduct that the plaintiffs are accusing the defendants of engaging in so that the defendants can prepare and defend against those. And it's just a simple concept. It's notice. Here, we did not ask questions of the jurors about sexual assault. That would have been a major focus of individual voir dire by the court and the parties had we known about Maya Kowalski's disclosure. We would have asked those jurors. Some of those jurors may or may not be seated here today, but we wouldn't know and have no way of knowing because we had no opportunity to ask those questions given the late disclosure. So I do not see how we can try the issue of a alleged sexual offense, again, assuming that what Maya Kowalski says is true. The ability to amend pleadings, even if you can amend pleadings during trial, and I'm not sure you can unless there's consent. But to amend pleadings, we look at a 3-pronged test. One, would it be futile? Well, clearly, if Maya Kowalski's allegations are correct, it would not be futile because as the plaintiff suggests, they want to bring a battery and a negligent security claim. Is there an abuse of the amendment? Well, we're on number 8, so that's probably a jump ball at this point in time. But the 3rd prong is prejudice. And here the prejudice to the defendant is more than palpable. It's extremely palpable because how are we able to try an issue when we haven't even asked the jurors who are seated on this jury about their views of sexual assault? So I don't see how we can do it. So we're now down to the question of, are the plaintiffs moving for a mistrial at this point in an effort to seek to add this in? Now, before you answer that question, let's think this through, Mr. Anderson. Assume for the sake of argument, you wanted a mistrial and I granted it. You added a count for battery. Assuming that the defense would be able to identify the individual, since what you're alleging is effectively criminal conduct, we're now going to be confronted with a 5th Amendment invocation, most likely, by the individual who Maya Kowalski would be accusing of this sexual assault. With the invocation of the 5th Amendment by that individual, that might mean this entire trial, if we granted a mistrial now, might then be suspended. I don't know if your client has made a report to the St. Petersburg Police Department for this sexual assault. I don't know if that's forthcoming. And if so, whether the state attorney would investigate it. I don't know what the statute of limitations is. I don't know what would be charged. I don't know the fact that she was a minor. So it is an entire panoply of issues that if you add a battery count for this issue is not a very neat and clean, oh, let's just bring it back. Perhaps that's why you were talking about negligent security, but at the same time, you're still going to have the same issue relative to identifying the individual who did it and possibly having a 5th Amendment invocation that would delay. So I'm going to deny the request to admit testimony by the witnesses on an issue that was not raised in the pleadings. And again, this is not that I don't believe or do believe, because for purposes of my motion ruling, I am assuming that what Maya Kowalski is saying is true. It's just how this was presented in the middle of trial is the prejudice is so severe that there would be no way we could continue with the trial in this posture, and we would have to go to a discussion of a mistrial. So I'm denying the motion to admit the evidence, and I'm denying the alternative motion to amend the complaint. So at this point, the question is, do the plaintiffs wish to move for a mistrial?
Obviously, we would need to consider that, Judge, that we have begun considering it. I believe that the court, and would ask the court to withhold final on this and allow us to at least bring in Dr. Katzenstein so that you can hear a proffer on that. And then if we can bring in Dr. Henschke and the court can hear a proffer on that, because I understand about the prejudice. What if the court concluded from the record that after the subpoena ducis tecum to Dr. Katzenstein and receipt of those records, that the court saw a marked increase in the amount of motion practice to exclude this? And the best way to do is ask as an officer of the court to them.
This one's a little bit of a red herring. And I know he has to make the argument. But increased motions practice around a subject matter does not give the defendant notice of the claim itself. So I know, look, this is a stretch argument. He knows the judge isn't going to let it in. He knows he's going to lose the argument on letting it in. And what he's trying to do is he's trying like hell to kind of, well, he wants to proffer evidence. He wants to basically say, Judge, this is how they were on notice. They knew during discovery that we were asking these questions. They should have known that this claim would have come up. But how do you know a claim about that specific incident is going to come up? And how does the entire entity as a whole know a claim if you haven't pled it? And not only that, but I think the pleading has constrained the court to what they can and cannot even surmise. I think if the judge allowed it in, I think that's overturned on appeal almost immediately. I don't see how that gets past an appellate court, that the judge would allow a new claim to be argued after a jury's impaneled. There's a magic window, and it begins when the jury is impaneled and seated. When that jury is seated, that's what you're arguing. You're there. You have questioned the jury. You have determined that this jury can be fair and impartial on these issues that were presented to the court. You can't bring in new issues and say, same jury. It's a very different thing. And I know that he wants to make this argument and needs to make this argument. It's not a winning argument. And I know that the unwanted touching was discussed in the motion in limine. I know that, but it was as to Ms. Beatty, not to this third party. The hospital had no notice there'd be a claim of a third party doing that. That's the problem. And the judge also highlighted another problem, which is the Fifth Amendment issue. If they make the accusation and it carries implications of something that's not just unlawful civilly, but criminal, then the person who's accused has the right to basically assert the Fifth, and then you put a stop to the case for more years while that's playing out. So it's a tough place that the judge is in. It's a tough place that plaintiff's counsel is in. I mean, heck, this is a tough place for everyone to be in. You discover something after trial begins, and you're left with the choice of, do I ask the court to dismiss everything and try to start all over again after, again, the 8th amended complaint and years of going back and forth? Or do we proceed on what we have and let that count, let that civil count fall by the wayside? Now, caveat, letting that civil count fall by the wayside does not mean that Maya cannot make a criminal referral or a criminal complaint. Maya can still go to St. Pete and say, this happened to me, please investigate. And they're allowed to do that. So there can still be a criminal prosecution for this. It just, the court is laying out that it's not properly brought here in this trial because the defense doesn't have notice of the actual specifics. It's not just the general allusion to it. It's not like when you're trying a murder case and all of a sudden additional information comes up. This is a brand new thing. It's a whole new count. It's a whole new complaint. So this basically starts back at one, like filing a new complaint. And you've already impaneled a jury. So this is a problem. And he's He's prattling, but, and this is a good point, you can't then pull the jury back up. Megan Brogdon makes it, pull the jury back up and say, hey, are you guys that are already seated on the jury, are you guys okay with going into this SA stuff? That's a different ball game. So
as whether after receipt of the either review of the Katzenstein notes or after receiving the Henschke notes, which I'd like to at least show the court, then if in fact they had that notice, regardless of whether we had picked up on it or not, because our client didn't tell us about it, and frankly, it wasn't something we were searching for here. If in fact they knew through this and chose tactically not to raise it, knowing that there's a possibility, as every good trial lawyer does, that things come out at trial, the court might reconsider this. I am adamant that any good trial lawyer having some notice or idea about this in reading, in particular, the Henschke records, would be aware, given our allegations against Ms. Beatty in this regard, would be aware that that issue was out there. And careful trial lawyering, both sides, careful trial lawyering on both sides is to the effect that you plan for things that could come in, as well as things that you don't think are going to come in, but possibly could come in. And so I beg the indulgence of the court. I know you spent a lot of time on this, but I beg the indulgence of the court to hear us out with some of this testimony. And what that would entail would be hearing from Dr. Henschke on it, hearing from Dr. Katzenstein on it, and questions as officers of court as to counsel about the unusual nature of the increase of motion practice about sexual misconduct after they received the Henschke records. I'm not accusing anybody of anything, but these are the facts.
The reality, though, is one, it's still not in the pleadings, which is a huge due process issue. And two, we did not ask the jurors any questions about what, and I'm telling you, having sat through many sexual assault trials, is a huge issue, and it's a fertile ground for cause challenges of jurors. And so there is no way that you can cure that prejudice by any sort of statement. Well, they knew about it even though we didn't tell them about it. So if your remedy would seem, there's always, if you think there's a fraud on the court, there's remedies you can engage in for fraud on the court. But at the end of the day, there is no pleading that supports this claim, and we did not address this issue in front of the jury. And I don't see how, even if you wanted me to wait for a further evaluation of information, how those two fundamental issues would change one bit. And those things cannot be changed at this time. So we're down to the question of, is there a mistrial motion or not?
Well, I can't make that call until I have a moment to talk to my client, obviously. We weren't sure of the court's ruling. I do also want to pull the transcript of the voir dire at the start.
Looking at the time again.
To ask questions about this in terms of Kathy Beatty. The defense objected vociferously on it. And so it was not a situation where the issue of that was just out of the blue. We had already raised that with Kathy Beatty. And my memory of that was that the defense was adamant that we not talk about that in front of the jurors at all. The court ultimately agreed, but that's not necessarily our fault because we foresaw that there were possibilities at this trial that Kathy Beatty would come forward in this regard. And so again, we want to make our record. I understand the court's direction. When would you like me to ask my client and what do you want me to do?
Well, we're about 3 minutes before having the jury come in. So obviously right this second's not, but I see no reason to spend a lot of time and energy going forward if one, you make a mistrial motion, and two, I grant it. I'm not saying I would grant it. I'm just saying I need to understand what you are moving for, if anything. The reality is, and that's why I put it out there about what would happen if you amended the pleadings to add a battery count, because I think you're going to run square into a Fifth Amendment issue. But hey, it's not my complaint. I'm just the guy calling balls and strikes. But I do think it needs to be said that the issue with Catherine Beatty had to do with the allegation that Maya, or that.
I do want to make a little interjection. I did like the judge's comment there. It's your complaint. You can decide what you want to do. I'm here calling balls and strikes, and I think the judge is done a pretty good job, like sitting behind that plate calling balls and strikes. He's been consistent.
That Miss Beatty placed Maya on her lap when she gave her a hug and things like that. It was not in the realm of what you're talking about in this allegation by Maya Kowalski with respect to the white slender guy with the lab coat that we see in the records that you are referring to.
As to the,
let me, because I've been letting you talk. I see Mr. Altenburn trying to say something, so let him say whatever he needs to say.
In light of the accusations that have come from the other side here in this public courtroom, I just want to state, as I think you have just explained, that my motions addressed to the issue of battery of this context were directed solely to that of Ms. Beatty, and it was based on the fact that we had taken depositions from Maya Kowalski and then various other discovery, and there was absolutely no evidence to have based an allegation in the complaint on a claim of sexual battery under the definitions in Florida law. So nothing of this was done to hide any evidence that we knew about at any time before this came up the other day.
Are there anything anything else we need to address before this jury comes in?
I wanted to announce that neither Kelly Perry nor Jennifer Anderson.
Oh, we had scheduling issues. So let me pull this down while I find the next timestamp. So in sum, here's the issue. The judge laid out his reasoning remarkably well. I thought that was very well reasoned. He basically said, look, you can't just amend the pleadings. And then I didn't really like what Anderson did there. Anderson went down this implication of impropriety on counsel's part. Now, we all know lawyers do shady stuff. We do. We all know lawyers do shady stuff. That doesn't change the fact that the hospital wasn't on formal notice that this was going to be a count that would be argued in front of the jury, regardless of whether any of this is true. And you heard counsel for plaintiff and counsel for defendant state emphatically, counsel for defendant says, we didn't do this. We had no notice of it. We were defending that accusation. I'm not getting into it. The judge doesn't get into it. When the judge rules on it, the judge says, I have to take these words as though they are true. They are fact. They are. And even if every single thing that was said, every single thing in that disclosure, that late disclosure is true, the prejudice to the defendant, the entity of allowing a amendment to the pleadings after a jury has been impaneled, you can't come back from that. Like I said, I think that's the swiftest kick in the butt from the Court of Appeals you'd ever get. And then you're back to trying it all again. And you still don't fix the issue. So it was a tough one. And I see the point from the plaintiffs trying to make it. And when they learn of it, I don't think they have an alternative but to try and get it in. So they made the effort and they did the best job at doing it. I don't really like how he did it by implying that there was impropriety on counsel's part, but attorneys are attorneys, and these attorneys have been dealing with this case for quite a while. So, yeah, that's kind of where we are. Let's go ahead and go forward to the next issue. So Jack Kowalski takes the stand, and when he testifies to essentially the treatment that was going on with Maya, the back and forth. He was allowed in. He had to disclose visitors. So now we get into the DCF stuff. A lot of objections come up on what he's allowed to testify to because there's the DCF involvement, and there's a lot of implication that the hospital and DCF are one and the same. You can't do that. The judge has said you have to walk this line pretty carefully. But we do get some pretty good information from Mr. Kowalski as far as the visitors that were allowed. So in one case, the judge in the dependency case ordered that Dr. Hannah be allowed to conduct a evaluation. Apparently, when Dr. Hannah showed up with the order saying I can conduct the evaluation, Hopkins, All Children's Hospital, said, no, you can't. And then there was other stuff. He tried to deliver a dress that was for Christmas because it was important to both Maya and to Mom. And the dress ends up in Kathy Beatty's office, not delivered to Maya. There's issues about the laptop being denied. There's issues about visitors being denied, things that are outside the scope of the orders. And I think a lot of this is going to come down to argument as far as what's allowed in or not allowed in. But we saw fireworks surrounding testimony about the videos. You guys remember from a while back, we were talking about videos and the allegation that Hopkins had placed Maya in a separate room for observation without parents' consent or knowledge. And that observation room was kept dark. It was to kind of track whether Maya was getting out of the bed of her own volition and could walk, despite the fact that she had previously been in a wheelchair. There was the, what is it called? What's the word, Rob? The facilities where you relieve yourself, the chamber pot. Chamber pot's a weird way of saying it, but that's the way I think of it. That being placed just a couple feet too far from the bed so that they could monitor whether she was getting up. Apparently they rang the phone in the room a couple times to see if she would get up and answer it. That was testified to, and I found that to be pretty credible. Then we get into the commode. Thank you, chat. The commode. Wow, chat is resounding. Chamber pot, commode. You guys can see how I got there mentally. That was testified to, but around the topics of the videos, Mr. Kowalski makes a statement. And when he goes down this testimony, I want to break it down in a minute, but I see why he's saying this. I see why he goes down this avenue. Plaintiff's counsel or plaintiffs, individuals that are in this lawsuit, they are emotional. They are emotionally charged. They've lived with the facts of this case for the entire case. They have been there. They have done this. They want to say a lot. And it's your job as the attorney to navigate them through the pitfalls that might exist because of previous orders. And even though they want to say a whole lot, you kind of have to manage what they want to say so that they're not saying something that might result in an admonishment or an instruction in front of the jury. And in one instance, when they're talking about the videos, Mr. Kowalski, and I know that he wanted to say this because I know he believes it in his heart, but there's prior rulings that say he can't, or he can't imply certain things. And he not to say he slips, but he goes to that emotional place and he testifies about it. And it results in a back and forth argument that ends up being rather significant. So let's go ahead and talk about this one a little bit later.
Jump to the photographs that you took that we alluded to just a moment ago. And believe you've, oh yeah. After October 20th, Nick has reminded me, after October 20th, when you witnessed or when you visited, did anyone tell you at the hospital about the video? That is the one that had just completed, about Maya's difficulties in the surveillance room?
Not at the hospital, no.
And had you had that complete video, would you have used it to demonstrate that your daughter actually was doing a lot worse than being represented?
This would have helped paint the picture to the judge.
Sustained.
I'm sorry.
You do a full day of legal work and you forget to hit the unmute button. Full day. Oh, Rob. Oh, you can do this. Okay. Stupid button, Rob. It's a button. Let me backtrack. The question was, if you had had this video, would you have used it? And Jack Kowalski is saying, yeah, I think it would have been impactful to use the video. And I brought up this question by Nathan, which is a good question. Legality of a secret video in her room and commode. So technically speaking, a hospital operating on the consent of both parties or a hospital operating a court order, they're allowed to supervise. There was a prior instance in this trial where there was testimony from Tampa Bay General, I think, where Maya had fallen and hurt her ankle. And the hospital asked Jack and Beata Kowalski, and they said, hey, can we set her up for monitoring to see if she's falling out of bed, getting out of bed? We want to see why the ankle was hurt. And Jack and Beata said, yeah, set up monitoring. This is different. This is after the initial order takes place where Maya is removed from their custody and care. And the hospital, from what I'm seeing and from what I'm gathering, acted on their own prerogative to place her in this observation room for 48 hours and monitor her. They didn't consult Jack or Beata before they did that. They just did. There's nothing within the orders that I saw that granted them that right to do that, to set her in this separate room. And they placed her in a separate room for monitoring purposes. And the legality of whether they could or couldn't do it is kind of the issue we're discussing here. That's what the jury is tasked with deciding, whether that was a battery, whether it was false imprisonment, whether it was any of the allegations the plaintiff has raised. It's a good question. So Nathan, that's the ultimate issue the jury's being tasked with right here. Any other questions? Want to double check? Happy Hippie, thank you. I feel like Dad's testimony hurt the plaintiff's case. I didn't believe him at all. People are going to be split on it. People are going to be split on it. I'm split on it. I think there were things he said that were believable, things he said that were tough to believe. So I'm going to leave people to make their own decisions. We need an Elaine mic emoji. You guys might. You might. It's just a thing. Nicholas, thank you very much. Is a family size apple pie a recommendation or a challenge? It's both recommendation and challenge. This is one I keep getting, and I want to answer it now because it's going to keep coming up. Question, Rob, can you explain the juror questions? Do all types of trials allow questions? Why was one question not answered? So this varies by jurisdiction, and it also varies by judge. So in Florida, apparently, and I did confirm with Peter, lawyer, who practices down there, the jury is encouraged to ask questions. They're allowed to ask questions of the testifying witness. And I'm torn about this. However, watching this trial play out, I kind of like the jury questions. I wouldn't if I was in the defense case. But the jury's been very, very good about asking those questions. When you ask the question of why didn't the judge read out one of the questions, because there's evidentiary reasons why. So what happens is at the end of the testimony given by a witness, direct exam, cross exam, redirect, recross, whatever you want to call it. When that's concluded, the judge will ask the jury, do you have questions? And that's where we're going to end our stream tonight, towards the end, because they had a lot of questions for Jack Kowalski. And the judge will confer with the attorneys to see which questions are appropriate and can be asked, and which questions they can't ask because of prior rulings or prior orders. They might imply DCF. They might open up the Chapter 39 immunity, but the judge and the attorneys go through, and the judge says, I'm going to ask these questions, and the witness has the opportunity to answer them. And then both attorneys get the opportunity to redirect or recross based on those questions. It's a good question. It's a very unique thing, and it's something that we're seeing play out. And I'm telling you, I've told you guys in the past, the jury in this case, they're like the third set of attorneys. They have asked some remarkable questions. It's been really pretty impressive. Bianca, what's the normal amount of motions if 52 are abnormal? It's not motions. Motions themselves, you see a lot of them. It's motions for summary judgment, which means take the case out of the jury. There's no disputable fact on this particular issue, and we deserve judgment as a matter of law. This complaint, I think, was 90 something pages, and I think there were 26 counts, and there was a lot that was argued of what could go before the jury. Those motions resulted in 52 orders. That's a lot. Usually there's one summary judgment motion and one summary judgment order, not usually this much. Lotus Bloom, thank you. As a person with CRPS, I'm so grateful that you're covering this case as it brings awareness to complex regional pain syndrome. Thank you. I think it's important because people don't understand it. So I'm trying to do my best to highlight a case that a lot of people aren't covering. Lee Drake, I was pretty shocked to hear the judge call the trial pretty clean, and I fell over. That's an indication of how complex the trial is. Matt Bond, glad to see you here, friend. Good day, spiffy, legal, mumbo, jumbo, talkie brother from another mother. I sent you a link for a gift for law nerds with chronic pain. I'll take a look at that. I might be able to post that tomorrow. I want to look at it before I do. Thanks for being here, and thanks for the contribution to the chat. I know that you suffer from CRPS, and you've shared your story throughout the chat, and I'm glad that you're watching this trial with all of us. So keep commenting, keep engaging, keep discussing. So let's get back to this.
Was that video of value to you in defending your family?
Objection calls for speculation.
Sustained.
What, if any, use would you have made of the information had they told you about this video? It's not speculation.
Okay, you can answer that question.
We would have took this video to prove Maya's condition. They were, unfortunately, it was a one-sided story. And if we had this would have painted a better picture to the judge at that time. And we probably wouldn't be here today.
So let's go through.
And that's the answer.
Religion photos, if we can, 2571-001. And after each one, I'll ask you to just kind of tell the jury what they're already seeing.
Your Honor, I apologize.
Yeah, he makes the approach, and it's a proper approach. You can't really allow him to keep going after he makes a statement like that, because there's an issue that needs to be corrected. And it's one that was made clear by the rulings in the summary judgment motions. So the judge excuses the jury. Spinny wheel, spinny wheel, spinny wheel. It's not the internet. Internet's great. Internet's doing great. I've got great stream feed. It's just spinny wheel. Stop spinny wheel. Come on. We can do this.
Not
Told
to
me
the
to pull.
investigation
There we go.
And receive no information.
Here we go. So as the jury exits, we have an issue that's going to get the judge a little bit upset. And it's going to result in a curative instruction.
I know we've discussed this before we even got to trial. The information was the plaintiff's attorney had this video. Was it November 6th or November 7th?
No, that's later. The date's important.
Okay, well, tell me the order I entered on this. Give me the DIN number on that because I distinctly recall it was like in early November,
It was mid-November, Your Honor, you're correct.
mid-November.
Yes. And just prior to that, there was a dependency review hearing on November 8th and November 10th. And Mr. Kowalski did not have this video or the benefit of it during the dependency review hearing. That's his testimony, that would have benefited.
It's not exactly what he said.
No,
And it's also contrary to both the order and the implication, because the specific order from the court was the plaintiff can't.
Can someone give me a DIN number,
So
please?
yes, Your Honor, the DIN number is 3032.
3032.
For which now, for the actual hospital video?
I guess November 17th, not November 7th. I agree with the defense on this, Mr. Anderson. As of November 17th, there can be no concealment issue with respect to this video because the plaintiff's or Mr. Kowalski's attorney had it.
Judge, at that time, we did not have all of the information from Deborah Salisbury. And
Are
here's,
you all working on a curative instruction at this point?
Yeah.
Because one's coming.
I would ask that you, and we can bring Deborah Salisbury in. This is all planned. And I did not understand the limitations on this video being provided to Deborah Salisbury. Here is her testimony. We can bring her over here right now to do it. Her testimony
You
is,
didn't understand. The court grants the motion to the extent plaintiffs seek to contend there was any fraudulent concealment on or after November 17th, 2016 relating to the secret video surveillance. What did you not understand about that?
I would like relief from it.
Okay, well, that's not what you just told me. You told me you didn't understand it.
Well,
So
maybe I got that. I got
you're
that.
asking reconsideration, or are you telling me you didn't understand the court order?
What I did, I may
Can you
not
answer
have
my
it straight.
question? Please answer my question.
I think I got confused on the court order as to the dates. That's the only thing and frankly, that was not the purpose of my question. I just asked whether it would be useful for him.
So the next decretal paragraph, the court denies the motion to the extent plaintiffs seek to contend there was fraudulent concealment prior to November 17th.
Judge, that's for the count on fraudulent concealment, is it not?
Judge is pissed. Judge is pissed. And like that's about as stern as we've seen the judge get. Not just give me the number, answer my question, answer my question. Judge is mad, and for good reason, and you'll hear why.
So are you saying this is medical malpractice?
Yes, and I'm also saying that it's part of our intentional infliction of emotional distress.
Well, to the extent that you are saying that there's an issue in the dependency court, you got a Chapter 39 immunity problem.
I
So you
understand
can't
about
do
that.
that.
But I think what I can do is show the basis of what was happening there in terms of whether Ms. Salisbury actually had
Oh my God.
the enough of the video and what the evidence will show.
Two comments real quick. One, appreciate the judge having a red pen. I like the judge having the red pen. That's a judge who he's about correcting stuff. Two, the little hand gesture over to defense counsel. Y'all better be writing up a curative, like write up a curative. I want to see it. It gives you an indication of how significant the judge is treating these issues. The judge has kept these parties in line. I mean, this is a tightrope to walk and to navigate and to keep a jury from being prejudiced by one person or the other. This was tough. And Anderson does walk it back. He does get the judge to kind of see how the mistake occurred and the emotionality of the parties that are involved. But this was a tough one, man.
Show is that it was brought over to, or she was brought over to defense counsel's office, not at DCF, but at Hillward and Henderson, and was shown snippets of it on the basis and telling her that this video, all this video shows is that she's in bed and we're going to use it to show that she's moving around. Miss Salisbury asked for it. She didn't get it. She finally got it. Then by the time that when she got it, she couldn't open it. We've had that problem before because she didn't have the codes to open it. So during the pertinent period of time, she did not actually have the video. What she had seen were about 3 different 2 to 3 minute spots. And what they were telling her was, we're going to use this to prove that Maya Kowalski can move around easily. And so the problem is she did not have, and we did not have until this litigation, the complete video to be able to look at it and pull out the things that the court just saw. And so we intend, if the court will allow it, we intend to show through Ms. Salisbury that contrary to their representations, and insofar as this being part of the Chapter 39, Hilward and Henderson was not supposed to be a prosecutor or a defense attorney in this. They were simply supposed to be a participant. So why they had this tape and were going to show it and make representations about this is another issue. But to the extent the court believed that Ms. Salisbury had the complete use of it, and therefore that is impugned on the plaintiff and then impugned onto our representations, that is a false statement. What Deborah Salisbury had were isolated clips under a representation. As a good counsel, she asked for it to receive it. When she first received it, it wasn't from DCF. It was from Hilward and Henderson. And so at that point, she attempted to open this thing. This is going to be her testimony. I'll bring her over right now if we need to. She attempted to open it, could not open it, had to obtain a code, a special means of showing this. Apparently it's coded some way that's difficult. And I'm not sure the timing after that, but I do know it was late in the proceedings, very late in the proceedings.
Well, one, you told me the issue that Ms. Salisbury had about 6 months ago. And I think you also talked to me about it 2 years ago. And you did not bring any testimony from Ms. Salisbury at any time. I don't recall after I entered this order on May 8th, 2023 at DIN 3032, that you filed any motion for relief from that. The time for discovery is over. Trial is not supposed to be by ambush in the state of Florida. Everyone's supposed to know, both sides are supposed to know what each side has. And I am sorry that you seem to misunderstand the court's order talking about this issue.
Only as the timing.
Yeah, before and after November 17th, I don't know how more clear I can be, but be that as it may, I'll grant you that you might be confused as to the meaning of November 17th. I need you to try the case and not continue to be on discovery. We were ahead. The last couple of days have been very bumpy and we're starting to slip. We've got a jury that continues to go out to deal with issues that should have been addressed before we even selected a jury. But we're at where we're at. Discovery's over. Trial. We're going to live with the orders that were previously entered. If you don't understand an order, please let me know.
In our
Hopefully timely.
in our defense, I believe that was an order in limine.
There's an order granting. and
Regarding
denying-
summary judgment on count 20.
I believe there was a follow-up motion in limine, and what I understood from the court was that since we had, I don't know how many motions in limine in this case, going into the dozens, that if there was an issue which arose at trial, that the court would
Outside the
reconsider.
presence of the jury.
I didn't know he was going to say that, Judge. I just asked him if it was of value to him.
Well,
I mean,
and
and
the
the next-
reality is, let's just go with,
I'll-
what do you have
I'll
a
go
recommendation for the proposed
I'll
curative?
make the recommendation that Mr. Alden will make it. Here's the reason why this is extremely problematic. The video, as Your Honor noted in his orders, was turned over to Ms. Salisbury on November 17, 2016. After the Kowalskis received the video, there was a shelter hearing on December 5th, 2016. And there was a shelter hearing on December 13th, 2016, both of which at a minimum would have been opportunities for the Kowalskis to present whatever evidence was in that video to the DCF court. So there's been a false implication in front of the jury that video, if provided timely, would have changed everything and Maya would have been told. It's also litigating the DCF action, which this court has instructed both parties on numerous occasions not to do. My colleague, Mr. Alden, is working on an instruction. We're very, very concerned about the last statement from Mr. Kowalski on the witness stand. That if we only turned over the video, everything would have been different. It's a clear violation of this court's order. It's a complete misstatement of the fact that the video was in the possessions of the Kowalskis for 2 subsequent hearings. And I think we have to move for a mistrial at this point, Your Honor, and we would reserve on that until the close of the case, but we do have to mark for the record that we are moving for mistrial.
Are you moving for a mistrial or are you not moving for a
Yes,
mistrial?
we are moving for mistrial. We'd ask the court to reserve.
What, Mr. Altenburn?
Here we go.
Proposed language.
There is our first of what I imagine will be many motions for mistrial based on this evidence or based on this, like just how complex this trial is. I put it in the title of the video. We've got mistrial motions already. You're going to get more. We're going to get more. We're going to get more. So defense counsel is moving for mistrial based on this. And we'll see. Once he says the word mistrial, I want you to watch how Anderson recalibrates.
Your Honor, on the fly, I think what I'm hearing that you should tell them that the jury is to ignore the testimony of Mr. Kowalski, that the videotape that was produced on November 17th would have made a difference in the DCF proceeding, that the hospital is not responsible for the orders entered by the court on the DCF proceeding.
Is that written out or is that?
No, I'm taking from my very bad handwriting to do that.
Could you say it again? I'll let-
Yes.
Can you read that to me again?
So I'm just reciting it. Hey, Can Can you read
You want
that?
me to read it?
Yes, that's probably better. You can open that.
Your Honor, on the fly, I think what I'm hearing that you should tell the jury is to ignore the testimony of Mr. Kowalski that the videotape that was produced on November 17th would have made a difference in the DCF proceeding, that the hospital is not responsible for the orders entered by the court in the DCF proceeding.
One point, Your Honor.
Judge is typing because he's already making a note of what he wants to write or rule.
Your thoughts, Mr. Anderson?
First, for the record, the December 5th and December 13th hearings were not on any merits of the case. They were purely procedural to deal with how Maya Kowalski was being treated and how the orders were to be modified in regard to that. So there was no opportunity at those. Our concern in this, besides the fact from the defense's perspective, it just merely highlights the testimony. Our concern is this: until the court hears Ms. Salisbury's testimony completely, which I have summarized, but by no means have made complete, we believe that it's objectionable to read any instruction that would diminish the plaintiff in front of the jury. And really, the question did not call for it. I'm sorry it went farther than I anticipated, but it was not intentional in any way, shape, or form. And until the court has all of the facts in this to make a determination, we do not believe that an instruction is important. We have to put on our whole case and at least get to Ms. Salisbury's testimony, and then the court can decide what it needs to do. For the record, I'd point out the number of orders in limine in this case makes trying to examine a witness a veritable minefield. And I simply wonder, given human beings being human beings, how it's, that it's going to be let me say this, it's very difficult for me up here questioning to constantly have to weave around these orders. That's the problem with trying the case in limine. So I understand the orders are there. I understood that the court was open to them. As to the summary judgment, the only thing I got mixed up on was about the November 17th versus the dates that mattered.
How would Rob make this argument? Tuck my tail. What Anderson did.
Your
Anderson
response.
immediately goes
In
to
response
kind of
to
panic
Mr.
mode.
Anderson's point, we'll just wait until we hear from Deborah Salisbury. The problem with that is, even assuming that Ms. Salisbury could not open the video, she had knowledge of the video indisputably no later than November 17th, and could have sought relief in front of the dependency court if she was having trouble opening it up, and could have addressed the issue in front of the dependency court. So here's what, based on what Mr. Altenburn said, let me read kind of where I'm at, but this is not a ruling. This is, let's just listen to it. The videotape that the jury has been seeing and discussing, or sorry, the videotape that the jury has been seeing most recently this morning was provided to the Kowalski family attorney on November 17th, 2016. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference in the dependency action. To be clear, defendant Johns Hopkins All Children's Hospital cannot be held responsible for court orders entered in the dependency action.
I think that's fine.
Your Honor, the second sentence there, that it would not have made a difference, implies that it could not have made a difference in the time before November 17th.
And that's our problem.
And that's our fraudulent concealment count is based on.
So would not have made it after November 17th.
Yes.
And it
that's
depends on
fine.
how much evidence we want to get in on this, because there were two lengthy hearings on November 5th and December 5th and December 13th.
Procedure.
And no one raised this then saying, we want to use this to change orders or to do anything. And so then the argument's going to have to be that they would have done something in that 30-day period that they didn't do in the 30-day period after they had this. And when the hearings were also taking place. So this becomes sort of an inference on an inference kind of problem as to what a judge would have ruled if he'd known something on November 10th when they didn't give it to him on December 10th, once they had the document.
This is a good time to bring this point up. Erica, Rob, why do the defense lawyers all get to speak and only one of the plaintiff's lawyers gets to speak at a time during the argument motions? That's the one area where I think this judge has been a little bit more relaxed. And I think it's an area where I think he can kind of, not that I would ever presume to give a judge, judges run a tight ship. So not that I would ever presume to tell a judge what they can and cannot do. But yeah, you guys will notice that usually it's one person sitting there at the podium who's arguing for the plaintiffs, and that's because plaintiffs had two lead counsel, and defense has, I think, 5. But there's issues here because defense has allocated issues between the different attorneys throughout the proceedings years back. So there's been one attorney that's handled the issue of false imprisonment, right? So one of them, that's that attorney's issue. So the judge is going to open the door because that's the attorney that knows what's being spoken about. But I also want to push back here because the judge also allows Mr. Whitney, I believe is his name, allows him to come up and allows him to interject. Now, these lawyers are talking over each other left, right, and center. Like I said, emotional trial, a lot of facts, a lot to navigate. And the judge is hearing from both sides. I do think that the defense, well, they have more lead counsel, and they're going to jump in and talk over each other. And like I said, if I was the judge, I would create a rule pretty quickly, like 1 horse, 1 rider. If you need to consult, you can consult, then make your argument, but 1 horse, 1 rider. But in the legal arguments, it's also more common for the lawyers to kind of jump in and add to the legal discussion because it's a discussion. The judge wants to make the right call. He wants information from all parties, and he doesn't want to constrain it to basically be the one lawyer at the podium. If the entire team has a position, he wants to hear the entire team's position. So I think it's been interesting. I think that's the one part of this that I kind of struggle with a little bit because I think defense counsel, they're really damn organized, folks. They are really organized. Defense counsel, and that's a lot of the money stuff. There's a whole lot of dollars being spent at that table, like a whole lot. And don't kid yourselves. This is a David versus Goliath case. You have 2 lead attorneys going against like 5. It's a tough case, but the judge has to weigh the legal merits of these arguments on the law. And when you're ruling on the law, you want all of the law, not just piecemeal. So you want to hear from everyone that's in the courtroom. It's just tough. Curtis Keller, why is the judge so emotional, getting angry? This judge is one of the least emotional judges I have seen. I made a comment on Twitter yesterday, I think, that if I was the judge, or if this were any other courtroom not broadcast publicly, the judge would have pulled these attorneys up and admonished them and yelled at them and said, get your shit in order, because a lot of the stuff we're dealing with evidence, we bypassed one of the arguments, but one of the things was Jack Kowalski was supposed to be on the stand for an hour today. An hour. And we go down this road of trying to introduce discovery violations and all this other stuff that was well outside the purview of what the jury needed to hear. And the judge tried to bring him back in, and he kept on going outside the bounds. And it was argument after argument after argument. And the judge is like, we've told the jury that we're going to be here for a certain period of time. You're not going to keep wasting that time. You told me an hour with this witness. We're now 3 hours in. This witness takes the whole damn day. So the judge is frustrated because the jury is sitting there going, I was going to be here for 8 weeks, and the judge has to keep this train moving. So I think the judge has been pretty good about this. But you guys can have a different opinion.
Argument summary judgment. The court made its decision November 17th, cut off deadline. So we're allowed to pursue this up until November 17th. There were 2 shelter review hearings on the 8th and the 10th, lengthy, full day hearings, where Mr. Kowalski had no knowledge of this video.
And they had a duty under their
Time out. I think Mr. Whitney has a point. So the second sentence, let me read it and get everyone's thoughts. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference to the extent that such statement applies on or after November 17th, 2016 in dependency action. To be clear, defendant J. Hatch cannot be held responsible for court orders in dependency action.
So to be clear, does that mean I'm going to have to start arguing and having evidence on relitigating the DCF and things and bring in people about whether it would have made a difference in the 30 days earlier? Because I mean, we're opening the can of worms that you didn't want to open.
It's a can of worms that was opened in the summary judgment orders and read multiple times. It's been known to the defense that this was an issue.
It's been known to me what we were going to try the case on, that we were not going to try the DCF case based on orders that were entered long before this trial began, Your Honor. And
His
now,
testimony is not in the hospital.
Time out. Can we just have one? at a
Time out. Children. Time out. Children, stop.
Count 20 has been limited to the time period prior to November 17th.
So the question, Your Honor, I think is, can Ms. Salisbury or some other lawyer get on the stand and opine as to what she would have done if she had been technologically capable of opening this when she claimed she couldn't, and what arguments she would have made, what arguments the DCF would have made, because John Hopkins wasn't a party, wasn't even attending those, and what ruling the judge would have made. We're stacking a whole bunch of circumstantial things together that looks to me like we're going down a black hole.
Well, I mean, anything after November 17th, we're not going there.
Yes.
That's clear. Count 20 specifically talks about the video surveillance.
Never really alleges that Ms. Salisbury would have done something different in that time period, in my recollection. It was very unclear what they were going to do, or that what they
Judge,
didn't
walk
do
back.
in reliance on the fact that they didn't know about this.
Well, I guess the best I can say at this point in time is count 20 prior to November 17th is a live count in this case.
There you go.
I'm
November
sorry,
20, November 17th. So
It is a live
17th.
count. I guess, again, I guess we have to wait till see whether they put her on the stand, but if we do that, it kind of changes what I visioned the scope of this to be as we were entering it through pre-trial.
I prefer to just take it one step at a time. If I'm understanding the court correctly, the last sentence was that the count remains alive.
Well, count 20 still is a live count to the extent it's prior to November 17th. Now, I'm going to reread the instruction one more time and see if there's any more tweaks that we need to give.
And by the way, Jason has been watching apparently, because this is kind of my take on this as well. Every one of these attorneys is a specialist in their field. Shapiro's a snarky gotcha guy. I think it doesn't play that well. I think the jury's kind of turned off by some of that. But Hunter is exactly that, a hunter. Yeah, he's kind of a spring on you. And I think that might alienate the jury. The woman is a genius in evidence and admissions. I like her on the defense team the best, just like I like Whitney on the plaintiff's team the best. I think those two are from litigation strategy standpoint, those two are my favorite. That's probably because they align with my mode of litigating. But every attorney has a personality, and man, they come out when these arguments hit the fan. Holy crap.
The videotape that the jury has been seeing most recently this morning was provided to the Kowalski's family attorney on November 17, 2016. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference to the extent that such statement applies on or after November 17, 2016 in the dependency action. To be clear, defendant Johns Hopkins All Children's Hospital cannot be held responsible for the court orders entered in the dependency action. Any other?
Yes, Judge. Technically, it would be the prior attorney. So I don't want to diminish my standing before the jury. So rather than saying her attorney, can you say her prior attorney? Or prior
Or the
counsel?
family's attorney at the time.
Yeah, the family's attorney.
I don't-
How about the Kowalski's family attorney in the dependency action?
Right.
Perfect.
But by the 17th, did they have separate lawyers? I don't know when at one point, and I think it's before the 17th, he had a lawyer and she had a lawyer. So there were two separate, he's testified to 4 lawyers, and that's what he's talking about.
All right, we're parsing language at this point. That's kind of the end of this clip. The judge gives a curative instruction, and that's kind of where we're left it. So the judge gives a curative instruction, says that if it's after the November 17th, they're not to regard that. But before November 17th, fair game. The dependency court, people have been asking this question. Dependency, juvenile dependency is something that Florida uses, other states use it as well. It's essentially where a court or a state agency jumps in to take safeguard over a dependent, and they make that ward, that child, they make them a dependent of the state. They say the child is either in a position of being abused, neglected, or abandoned, and therefore the state jumps in. They say, we're going to remove the child from the care and custody of the parents, and we will put them within the jurisdiction of the dependency court to make rulings that are appropriate to try and create a reunification plan so the parents can either be re-educated or be allowed corrective instruction or can go to rehab or whatever you need to do in that moment. That's the province of the dependency court. So that gets referred to quite often. The dependency court lays out orders in this case that create a variable minefield for people to navigate. And it does become kind of a challenge. I spoke too soon. I do want to have the judge's ruling on this because the judge does make an observation I think is pretty important.
Is that they ended up having 2 different lawyers pretty early on.
And Ms. Salisbury represent who on the 17th?
In fact, I can. Just hang on.
Mr. Altenberg, any other, did you want to say anything on the mistrial motion?
Judge, the error, and we're not conceding there was, but if there was error here, it certainly did not go to the point where it would so prejudice the jury in their review, particularly with the instruction, which I think cures anything. I would simply point out that this case is incredibly complex and difficult to try for anyone, and I'm sure with the court too, with the number of orders in limine and summary. We have 52 summary judgment orders. And I've lost count of the number of orders in limine. I believe in this case that there's going to be more than one incident where a question brings out something, no matter how much the plaintiff's counsel instructs witnesses, including their client, no matter how much we instruct them, they're
Yep.
human beings. And they
That's
don't go as
right.
programmed a lot. So my concern on these motions are that the defense wanted them entered, and now we should have some understanding of the difficulty in this case, and that really at this point there is completely insufficient problems to impress this jury to the point where they cannot receive a fair trial, particularly with the instruction.
Anything else, Mr.
Jake,
Sure.
very briefly, the reason for the mistrial is not simply a violation of the motion in limine. It's intentionally walking a witness through questions that knowingly we're going to end with a response that if only something was given to me, the dependency action would have turned out differently, implying that all children is responsible for taking Maya Kowalski away.
That is-
I believe this is the third time that the court has had to give a curative instruction to this jury in this short trial that we've already been through, telling this jury all children. are
Second,
responsible
Shapiro.
For Maya being taken into state custody. And so it's the cumulative effect of all this. It's not just merely.
And when you get your case, I'm sure there's gonna be more.
The intention of walking a witness to a statement that this court's instructed multiple times is not a subject of litigation because we do have immunity. Thank you. Your Honor.
I categorically deny.
I'm going to deny the mistrial motion. I will say, honestly, I think that the trial has been cleaner than I anticipated it was going to be by this time. Honestly, and that's a tribute to the lawyers. And I think the credit needs to go to the lawyers. The concern I had when that question was raised, which has been articulated by Mr. Shapiro, is the impression it gave to the jury that somehow this video would have caused none of this to have happened. And I think that this curative instruction specifically and directly addresses that perception that Mr. Kowalski's statement could have been given to the jury. And it's done timely, it's done right away. And so I don't see a basis, I don't see a cumulative basis for a mistrial. I'm comfortable with this curative instruction, and it will, I'm confident will ensure that this jury does not take a false implication from Mr. Kowalski's statement.
Yes,
I'd really like to bring the jury back in.
and I really want to not get another mistrial motion. So I wanted to ask the question. The question that was coming next was this, would this video have been of value to you? And he knows not to say anything about substituting it in or reopening the proceedings. But there are two things it's good for. The first is for him to understand what was going on with his daughter. And that goes secondarily to the damages in terms of emotional distress and so forth.
Well, I'm assuming that you are restricting your question to a date range to which it applies. Yes.
Right.
And Your Honor, just to make something clear in the record, I've checked my personal notes, having read the transcripts of the DCF proceedings, and it appears that on November 10th, Ms. Alberry appeared for both parents, and then on December 5th, they each had separate counsel. So
Okay, that was what I wanted to get in, the mistrial thing, and the judge kind of ruling like this trial has been cleaner than what I thought it would have been. I have talked repeatedly about how this trial in particular is a variable minefield of missteps and misstatements and things that are alluding to orders that were entered by the court that you can't question, immunity defenses, various defendants. I mean, this trial is walking a tightrope, juggling plates that are fine china. Like this is not easy. And the judge highlights that. And for those of you who are trying to say that there's bias by one person or the other, you're allowed to make your conclusion. I've seen enough of these trials from start to finish where we're in the plaintiff's case, and every ruling that goes against the plaintiff is going to feel not right. It's going to feel wrong because we're in the plaintiff's case and they're trying to prove their case and you want to hear their case. Conversely, when the defense gets on, every ruling that goes against them, you're going to say, well, it's biased for the plaintiff. This judge has made both people pissed off on both sides. I think he's done it equally. I think the judge is running a good ship. I think this judge has done a good job. I think the plaintiff's counsel has, they've done what they can. Defense counsel's done what they can. I'm not disparaging any one of these attorneys in this case. I think that the case is moving forward. I think the jury is kind of going, holy smokes, man, this is a lot. And well, no, I don't think the jury's saying that. I think the jury, the other part about the judge I think is important is the judge has immunized the jury from a lot of this stuff. There's a lot of back and forth in motions practice, a lot of snark that's thrown back and forth between these attorneys. The judge has done a good job of immunizing the jury against that. This jury is still engaged. They're still positive. They're still asking questions. They're still there. They're not, I don't get the impression that the jury is being made privy to a lot of these behind the curtain discussions. I applaud the judge for that. This isn't being meted out in admonishments from the bench in front of the jury. Both attorneys are standing in pretty high regard in front of the jury. So I think this has been pretty good. I mean, the attorneys are playing their roles. They're playing their roles. They're doing their job. That's their job. It's not one that, I ever think they want to do. They're just, it's just their job. It's the job of the attorney. So then we go into the lunch break, and after the lunch break, we go back into evidence. We get a little bit of a warning that tomorrow FEMA is going to be testing. If you guys didn't know this, tomorrow FEMA is going to be testing their cell phone notification service. So I think at around 2 something p.m., every cell phone owned by a person within the continental United States, within the US, is going to start blaring and beeping. So the judge is kind of saying, we might just excuse everyone for that because I don't want a million cell phones going off. Let me get some questions before we jump back into the afternoon session. A rambling Southerner, thank you. A man who pops up for the defense during every argument, Chris Altenbrand, is a retired appeals court judge. He's made good arguments. He has. So there's that. Catching up a little bit more. Sadie Jane, on a stupid law question, or no stupid questions, but if the lawyer knows who committed the crime, don't they have to name them? As he's really not their client, just an employee of their client. You mean at the defense counsel? The burden is actually a lot higher. It's actual knowledge. So they have to possess actual knowledge, not just being told that something happened, and there's no duty to investigate. So that's part of privilege. And that gets actually a lot more complex when we talk about schools and hospitals, because that privilege extends down to the employees in some regard, but where it cuts off is a moving line. That gets to the motion. I think the rest of that kind of is a little outside the field of where we're going here. I hope I answered your question. I'm not sure if I did. No, they don't have an obligation to name them unless they have actual knowledge of what was committed. Laura Leanne, thank you. Did the Kowalskis use the same lawyers for the other cases that have settled already? Yes. Just seems too unorganized. It's frustrating. It's a lot to juggle, and now we're in trial, which means, now we're in trial. And Anderson laments it's 18-hour days already. It is. I've been there. It sucks. When you have multi-week trials, when you have multi-day trials, this is a different ball game. So you expect like a little bit more disorganization. And the judge has been sympathetic to both sides in that regard. What's in the video? The video itself is depicting Maya in that room, the darkened room where you can see that they put the commode outside of her reach. And Jack Kowalski's point was, if we had that, if we had known they were doing that, they were trying to prove Munchausen by proxy, we would have raised it to the judge. That's the point that he was trying to make. LNG, thanks for becoming a member. Nathan C, do most trial attorneys and judges have hair loss? Mine's doing okay, I think. I don't know. We get gray a lot faster. Yeah. Laura Leanne, jury probably help lawyers so they understand them more. Yep. And then Dreamscape, trials easier to listen on 1.5 speed. Yeah. So let's get in the afternoon session. We begin with the question of whether the plaintiffs are going to make a motion for mistrial. And that's where we start talking about the afternoon.
What's the next issue?
Plaintiffs move for a mistrial based on the failure to allow the entry of the evidence of Maya Kowalski having been sexually assaulted at Johns Hopkins Children's Hospital. We will follow up with a proffer from Maya Kowalski of exactly what happened. We note that both Jacqueline Henschke and Dr. Kassenstein from Johns Hopkins, Dr. Henschke independently have verified this, and we have an independent witness. Still, we understand the court's position on this. However, since we have, I believe we can show that the defense has known about this for a considerable period of time before we ever had voir dire, and if once we get a transcript, we can show that questions similar or about this were asked during the course of the voir dire. I don't know the exact wording, Your Honor, and you were there too, but I believe we went into the extent of battery. That's just from memory, and your court may remember it different, but I remember the subject came up. Now, whether they were asked or not, we'll have to see. If in fact there was enough brought up so the court feels comfortable on that, we hope to be offered a rehearing on it. There are other bases, but at this point under the case law, we ask the court to suspend any ruling on that till the end of the case. The parties have spent enormous amounts of time and money. This court has spent enormous amounts of time getting this case to trial, and it would be an abject shame if we had to terminate it after all this work we've done. 5 years, 52 summary judgments this court has heard, and we don't want at this point for the court to stop the trial. We want to move forward. We simply want to note for the record on the present second DCA case law the importance of this testimony.
So you're moving but not moving for a mistrial.
I am moving, but asking court not to rule until the end of the case.
Really, really weird, right? Give me a mistrial, but don't rule on it until the end of the case. He doesn't want a mistrial. He doesn't want a mistrial. He doesn't want to go back to the gut. He doesn't want to go back to the start line. Give me a mistrial, but don't give me a mistrial. Hold on. Don't do it yet. Nicole, I didn't know this was a thing. It's not a thing. It might be. I don't know. It's kind of strange, right? So, Judge, give me a mistrial, but wait until I present all my evidence and know the confidence that I have going into closing arguments. Kind of feels like a give me everything. Like, give me my cake and let me eat it too. And the judge is pretty clear, like, I'm not going to do that. I'm not gonna let you go all the way to the end of the trial, because the argument he's making about the cost that it took to get here, you know how much that cost goes up if they go through the end of the trial and the judge is like, oh, I'm gonna grant mistrial now. No, that doesn't make sense. Yeah, it's not a practice. You don't get to do it over again. No. So I like the, you know what? Good screen grab, Rob. Good pause game. The judge's face right here is looking kind of going, yeah. No, we're not going to do that. No. Like, I like the move. I like it. It's clever. Like, well played, but no, we're not doing that.
I believe I can do that under the present case law. If I am in error in that, let me know, because I may then withdraw that motion.
The defense objects and believes that the plaintiff has mischaracterized the mistrial rule. We would ask the court to deny the motion for mistrial. I can give the basis, but procedurally, that's not something they can defer until the close of evidence. We would ask that to be ruled on now before this entire tribunal spends 6 more weeks in enormous expense. I can respond further if you want to take a look at time. You can relay the record.
Now's the time if there's anything you want to say on it.
I do want to say one other issue. I will tell this as an officer of the court. I've spoken with Dr. Katzenstein. The note that she wrote is specifically this. Quote, she denied a history of sexual abuse. This is coming from Maya. Quote, she stated one time previously a doctor had looked at her private parts but did not touch her, and it made her feel uncomfortable. I've spoken with Dr. Katzenstein. Her testimony in this court will be that Maya told her that that was from another hospital. That was not at L Children's Hospital. Dr. Katzenstein will testify that there's a very strict protocol at L Children's, and that she specifically would have asked Maya, did that happen here? Because if it did, it would have triggered an investigation. So for the record, All Children's absolutely denies, based on what Dr. Katzenstein's testimony will get evidence she was told about some type of an assault, or really what's being described here, how it's being described, inappropriate conduct that occurred at All Children's Hospital. That being noted, in terms of the surprise, I think Your Honor's already laid out nicely, the prejudice in terms of jury selection.
I know, I can't fix the mic.
There's no way we could have known about an allegation the plaintiff themselves said they were completely unaware of. And the note from Dr. Katzenstein does not say that there was something that happened at All Children's that she will disclaim. That's all, Your Honor. Thank you.
Anything else? I know Mr. Hughes was whispering in your ear.
Nothing else, Your Honor.
Anything in rebuttal?
Yes, Your Honor. Maya Kowalski would be the best witness as to that, and it would be very interesting to cross-examine Dr. Katzenstein, given the absolute obligation, once that was raised, as to anyone, anywhere, by a child to report that. So we will welcome the opportunity to cross-examine Dr. Katzenstein on that. The biggest concern is Dr. Henschke's records, which the defense has had since March of 2022, and which have much more detailed information pinpointing where and how this happened. And so it's still not complete, but it certainly would put any reasonable attorney on notice that this had occurred. We did not, because we were attempting, if the court will recall, to make Dr. Henschke a safe harbor for Maya, so that she could tell Dr. Katzenstein anything that she wanted, so that it would help reduce the stress and strain on her. That did not happen. And through the course of the deposition of Dr. Katzenstein, which was on Zoom, that was never asked. And I confess that we didn't start going over a lot of the records until Dr. Katzenstein was flying in. Had, of course, our client informed us that this was something that was going on, we would have looked again at Dr. Katzenstein's records, and we would have probed more of the records of Dr. Henschke to be able to bring this to the court's attention. Basically, that the defense had greater knowledge at this point, the record I believe shows, than the plaintiffs did, given the plaintiffs, Maya Kowalski's direct denial for 5 years, not denial, but failure. She didn't deny it. She just failed to tell us about it for 5 years. So frankly, I wasn't on the lookout for it.
The issue has to do with whether to grant plaintiff's motion for mistrial. It appears the plaintiff is contending that the court made an incorrect ruling on the denial of allowing the newly discovered evidence, if that's the phrase we're going to use, into this trial when that is outside the pleadings and was not disclosed to the court and potentially the defense until after the jury had been sworn and the trial started. The court does not believe it abused its discretion in denying the motion, and I laid out earlier this morning the court's view on that particular issue. I'll reaffirm that ruling, and because there has been no violation to the plaintiff and no prejudice to the plaintiff, at the end of the day, this still was within the ambit of the plaintiff's knowledge. I understand the circumstances may be such that Maya Kowalski didn't recollect this until more recently, but you know, we are where we're at. I don't believe there's been any incorrect ruling, and so I will deny the motion for mistrial.
We understand the court's ruling. Let me continue. We have one more matter.
Next issue.
The court had requested, I think twice, for us to come up with a stipulation as to the lien issue, and if I could.
Yeah, we're not going to that because that goes into a lot more. All right. Before we go too much further, I do want to kind of shout out one of the people you're going to see in the chat, one of the people you see in the courtroom, Jules, who's in the chat giving commentary on what she's seen with the jury. Jules has been in court every single day. She's in the back of the courtroom. You can kind of see her over counsel's shoulder every now and then. She's been messaging me with little updates here and there. It's been helpful just being able to chat with her. And honestly, the input that she gives on these recaps is pretty awesome. So I did want to shout her out. If you guys, she doesn't have a YouTube channel, but she does have a TikTok. For those of you that are on the TikTok, if you're on the TikTok, the TikTok is blind_gossip. I leave it to your discretion if you want to check that out or not. It's up to you entirely, but I did want to give that a shout out because she has been doing some coverage on this trial. So we went into that. You heard mistrial denied. No, you don't get a mistrial. You do not get to restart. And then we start getting into cross-examination by Mr. Shapiro. And cross begins at 1:02. Scroll. Here we go. We're going to listen to the first minute or two of cross. Then we're going to go to a point in cross that's going to come up later during the jury questions.
Going back to July 3rd, 2015, just so this jury's clear, there was never a physical injury that started Maya's ordeal that put her in the wheelchair, correct?
Not on that date. Like I stated earlier, there was an injury when she was in gymnastics, but we cannot pinpoint it on that.
The jury saw the video of Maya riding her bike on July 3rd in the parade. It's your testimony that that night she had some type of a panic attack over something and immediately experienced global pain. Is that true?
Not true. She didn't.
Hey, let me pause. It feels like kind of quiet to me real quick. So let me check something really quickly. Make sure that I am up on volume on this one. I wasn't, so you guys were right. This one's quiet. Apologies. It's going to be a little louder. Adding it back. Continuing cross.
Didn't have a panic attack. She had an asthma attack.
So-
And she had some previous to that.
So in terms of what happened that day, once Maya had an asthma attack, correct?
Not right away. She had difficulty breathing and then chest pain, I believe it was in that record. I could be wrong.
Before you brought her to All Children's Hospital, you applied for Social Security disability for Maya, true?
Objection. Yeah, that's not specific.
Okay, so I'll clarify.
Approach, please.
Already. The sidebars that occur, lots of them. Okay. This one's not a big one. We're going to go forward to the next point that I wanted to make, which was there was a recording by a detective. It was 1:18:32.
You may continue, Mr. Shapiro.
Thank you. With the court's permission, I'd like to play clip 6 from an interview that Mr. Kowalski gave with Detective Graham.
I was told here at the hospital upon her admission, and maybe some of this will shine a light on at home too. When nobody else was in the room but Maya and the staff, she acted completely normal. When mom would walk in the room, she was instantly.
I heard that many times.
There's no other explanation.
The
for that.
jury
I
asked
noticed that too,
questions.
if myself be home and then mom comes home from work,
And all of a sudden she's bad.
there'll be changes. Yes.
So you're at home, your guys are doing well, playing.
No complaints about pain.
No complaints
But
about
then when mom gets home,
She's
maybe.
okay.
Mr. Kowalski, do you recall that interview was with Detective Graham on November 17th, 2016?
I do.
And everything you said to Detective Graham that day was true, correct?
That is true. And then after reviewing medical records in your hospital notes, it states that she did the same thing for me.
In terms of the timeline, did you go to Mexico when Maya was being put into the coma?
We addressed that earlier. I went to my oldest daughter's wedding. And then from there, I took my son back to Florida, and then I proceeded back to Mexico.
Were you aware that the risk of death from that coma was 50%?
There's a risk in every procedure.
Well, I understand that, Mr. Kowalski, but respectfully, there's a risk, and then there's a risk that's a coin flip whether your daughter would unfortunately pass. Did you know that the risk of death in Mexico was 50%?
They stated there was a 50% risk, but they also told us nobody ever died from that procedure.
Are you aware of what complications Maya suffered while she was under her coma in Mexico?
We were informed.
Okay. Your wife blogged about those, did she not?
Sorry, just moving closed
She had
captioning.
a blog.
Okay. And part of her blog was, you've seen the blogs, true?
No, I have not.
You're aware that your wife was blogging about Maya's care while Maya was in the coma. Is that true?
Yes.
Okay.
I don't know if you ever had a sick person in your family, everybody calling you, and you're repeating the same story over and over. This was a way of communicating to everybody at once.
All right, a couple of comments on this one. Jack's a little combative here. He was combative throughout the cross, but it wasn't overly combative. It was kind of what I would expect a plaintiff to be engaging with defense counsel who's asking pointed questions. Shapiro was chosen for a reason for this. Shapiro asked questions that are very, almost feel insulting. He's doing that by design. It's to get Jack Kowalski to be combative with him. And I thought Jack didn't do the best job, but he did a pretty good job. People were asking about the audio recording with the officer, detective. People were saying, was that legal? Surprise, a bunch of the jury questions were revolving around that exact thing. It was very curious that the jury is, you guys are really great at this because you're asking similar questions to what the jury ends up asking and focusing on. So I know that Peter says it, lawyer, says that, like, you guys are prospective jurors. All of you are. And I thought that was a very curious point. The point that Shapiro made that I thought was like, that stung a little bit. Like, Mr. Kowalski, you do recognize there's a difference between like a chance or a risk and a 50-50 coin flip. That point came across to me. It came across. So there was stuff there. Now, as we move on, and I'm gonna fast forward a bit while I'm talking, pull this down while I do. As we move on, Shapiro starts going into different questions about, what felt very strange to me was this concept of Jack Kowalski separating, filing for legal separation in Florida, so that he could essentially get the kids back or have the kids released to his care. This felt awkward to me because I didn't really realize this was coming up or this would be coming in. And the implications were kind of strange, but I understood it from both parts. Florida is one of those states that has a filing for legal separation, apparently. Virginia, we don't. But you can file for legal separation, and that has some, I guess, legal ramifications to the filing itself. And the point that Shapiro was trying to make was that there was animosity, or there was a rift between Jack Kowalski and Beata Kowalski. I don't think that really resonated that much, because Jack Kowalski was pretty adamant that what he was doing, yes, he was concerned about his wife. Yes, there was tension. That's imaginable. I would never want to be in that household. And I don't wish that upon anybody dealing in family circumstances where you have tensions between the husband and wife. And at the center of that is a very taxing diagnosis for your child, and situation that I don't think any marriage is adequately tested for before saying those vows. But I don't know that Shapiro landed the point, because Jack Kowalski came back and was making it very clear. Rather, I thought he made it pretty clear. I don't know. The chat might disagree. I thought he made it pretty clear he was doing this because it was focused on getting Maya out of that hospital, and that there were concerns that Jack had about Beata and her health that he wanted her to address, and that she had those same concerns. I think Jack did a pretty good job of dancing that line of the concerns were there, but they were not the fundamental foundation for this decision. Anyways, going forward, Shapiro steps in it a bit. And he steps in it a bit when he's talking about diagnoses and the coding for all of this. What the diagnosis was that was being billed for. And can you really say that the percentage of the billing that you identified as being billed for CRPS, can you say what percentage of that billing was for CRPS versus the other things, asthma, etc.? And Jack Kowalski says, no, I can't give you the percentage. And we start to get to this point of the discharge instructions and how the Kowalskis refused to sign the transfer paperwork because it had the diagnosis of Munchausen by proxy, or it had the transfer diagnosis of Munchausen by proxy. And the question is, has Maya ever been diagnosed with Munchausen by proxy? Mr. Shapiro starts asking a lot of questions about refuting the diagnosis. And he really is walking this fine line of you didn't refute the diagnosis, but implying that it's the Munchausen by proxy. And he kind of steps in it. And let's see where we go with that.
True.
Somebody like that.
And your complaint was that you didn't understand how they were able to access Maya's room without your permission. True.
I was concerned not only for them, but the other people that went in there as well.
You
I
didn't-
did not want to lose my privileges.
You didn't authorize them to come to Maya's room either, did you, sir?
I don't have that authority.
Let me ask you about, you were asked by your counsel about some transfer diagnoses. Okay.
Yes,
You're not denying to this jury that as of November, after Maya was sheltered by order of the state in early November, you and your wife had the opportunity to consent for Maya being transferred out of All Children's Hospital, but you and Beata refused.
that is correct.
Let me ask you about one of the other documents in that issue as well. Well,
And that wasn't you and Beata. Beata refused. I remember that.
okay. But just so this is clear, in November, Maya could have left Bell Children's if Beata had said yes.
She could have, but we weren't going to do it under that diagnosis.
The diagnosis code that had already been made at Lurie Children's, Tampa General, and at Dr. Mendez' office, true?
Objection, as objection on evidence.
Did you get the point? Do you hear it? She wasn't going to do it because of the diagnosis. The prior question was diagnosis of Munchausen's by proxy. She wasn't going to do it under that diagnosis, Munchausen's by proxy. And then Shapiro goes, you mean the diagnosis that was made by boom, 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 going back down the road. And immediately I was going, whoa, wait, that's not the same thing. And counsel jumps up and says foundation. I think counsel missed a little bit of a point here. I almost would have asked for a sidebar here, but the judge is giving leeway. I think Shapiro knows exactly what he's doing here. He knows exactly what he's doing. And this was a little bit slippery.
Mistake the evidence and
Sustained.
having comment on it.
Sustained.
Sustained.
And
So-
Mr. Shapiro, the jury's been seated for over an hour and 30 minutes.
Now's a good time for a break, sir.
Now's a good time. Now, members of the jury, this is going to be your last break of the day, hopefully. Let's try to keep this to 10 minutes. Let's do not discuss this case amongst yourselves. Do not do any investigation, receive no information.
All right.
All right, now we get into argument.
Motion, Your Honor.
You're out of the room.
Let's talk. What's your motion?
Judge, we objected and we're moving for a curative instruction because nowhere in those records does it say Munchausen by proxy. All
Did
it
the
says
judge
is
say, hang on, did the judge say what's up?
conversion disorder. Moving for a curative instruction because nowhere,
Jury's out of our presence. Let's talk scheduling for just a moment.
I have a motion, Your Honor.
Let's talk. What's your motion?
What's up? What's your
Judge, we objected and we're moving for a curative instruction because nowhere in those records does it say Munchausen by proxy. All it says is conversion disorder. It simply means that they believed that Maya believed, but there was no, that there was pain, but there was no organic. There's a huge difference between Munchausen by proxy, which is a criminal act, and conversion disorder. And if they can show me in any of those records where it actually says Munchausen by proxy as diagnosis, let's see it. He said it was Lurie and
What am I looking at? The memorial?
This is a record from Dr. Mendez.
That's not TGH, that's not Lurie, that's not diagnosis. It's not a diagnosis. It's up.
Do you have a document from either TGH or Lurie's that says Munchausen by
I
proxy?
believe my question was conversion or Munchausen by proxy.
Answer the question. Do you have a document from Lurie's or Tampa General that says Munchausen by proxy?
Not Munchausen, but conversion disorder. Factitious disorder. Factitious disorder.
No, but it's not factitious.
Factitious disorder.
Folks,
Sorry.
what I would recommend is get some language, and then we'll talk about it. But, you know, I'm going to need to see whatever record or records are from Lurie's and Tampa General that underlie the question. So
Can we have the question read back so that we can request instruction?
I think that was a mistake. Can we have the question read back? I think that was the mistake. I wouldn't have focused on that because, and it's not really the mistake. It's one of those things where you know it's there and you feel it, you can hear it, but it was two questions before. It was a question, answer, and then the follow-up question. That's what you needed to understand. It was misleading. It was misleading. And the way that Shapiro tries to respond to the judge's question of, well, you know, it's not, we have this suggestion, and the judge is like, no, I asked you a question, answer the question. And this gets really interesting. And I do like Anderson's argument here. I think he goes a little too far, and I think that's why the judge doesn't give the curative. But Anderson does a good job of putting the court on notice. This is going to be a repeat issue. We're not dropping this. So we're going to watch this to the conclusion, then we're going to get to the jury questions.
I really want to go to the restroom myself. So yes, you can go. And I don't know.
It was the last question. Cross-examination.
Perhaps after everyone uses the restroom, the court reporter would be so kind to help you all out with that particular question. Let's talk schedule for a moment. Mr. Shapiro, how much, I know you
Person
said
who
an hour.
understands P breaks. I appreciate the P break. So, Judge, thank you for taking the P break because we all need to use the facilities.
That it's already been made at Lurie Children's, Tampa General, and at Dr. Mendez's office. True, and we have the objection.
Court feed, court TV, and lawn crime. I really hate you for not picking up that audio. I really hate you for not picking that up, that audio, because you're already hearing questions, and it's like, I wanted to hear what was being argued. We're going to go back and we'll listen to kind of where it starts. And the audio picks up, not right on point, and it kind of bothered me that it did.
That it's already been made at Lurie Children's, Tampa General, and at Dr. Mendez's office. True, and we have the objection.
Let's read back
For
the
the records
question.
of Munchausen, that's what Dr. Mendez's records get used for.
My implication from the question was 3 prior institutions had already put in the records that there was a psychiatric diagnosis to this illness, with the implication being that the plaintiff's point in this case is we weren't going to agree to any transfer.
This illness, Mr. Shapiro, what's this illness? What's this illness? Because that's knowing he stepped in it and going, no, like, yeah, no.
That contains something referencing a psychiatric diagnosis. The rebuttal is it's already in the records. We weren't the first ones to put it in there. You're signing this doesn't indicate that there's anything new. That was the intent of the question, Your Honor. But I didn't specifically say Munchausen by proxy is in all 3 of the records.
Remind me, the Lee Memorial,
Is Munchausen.
was Maya an inpatient there?
She went to see her allergist, and during the appointment, he said suspicion for Munchausen's needs to be considered.
And that's the difference.
That's the difference.
The Lee Memorial.
That's the difference.
admission then.
I don't think I represented it was an admission.
The problem.
Jules, I have a question for you because Hughes, this is like the first time I've seen him jump up out of his chair. This is a question for Jules, who was in the courtroom. Hughes is the guy in the back with the glasses that you see with the curly hair and the blue suit, who's standing behind defense counsel when we resume. This is the first time I've seen him jump out of his chair to go and address defense counsel. And usually defense counsel comes back to him. For those of you who don't know, he's the lead attorney for the defense. He's the lead attorney. You see the trial attorneys up front, the people that are trying the case. Hughes is the lead attorney for the defense. And he's like the Ben Chu of the defense side of this case. And Hughes jumped out of his seat, man. I hadn't seen him move like that the entire trial.
Your Honor, the term diagnosis. There's a huge difference between a doctor saying consideration must be given or thoughts may be carried. There are 7 different theories that they were trying to figure out. The question as posed puts it as a certainty that Lurie's, Tampa General, and then Menendez here all diagnosed Maya with Munchausen by proxy. Now, leaving aside for a moment the question of whether anybody there was qualified to do so, and whether there's a report in saying that, which there isn't by any psychologist or any psychiatrist. The fact is that what they're trying to do is get in something through the back door that they cannot get in through the front door because they don't have a single expert that says that Maya Kowalski had Munchausen by proxy, because they gave up their CME, and without that, no psychologist or psychiatrist is going to get up there and say that. So right now we're in a situation where the jury thinks that this is an ongoing diagnosis. And so we ask the court to instruct the jury that until shown otherwise in the record of a diagnosis, that there is no diagnosis of Munchausen by proxy at any time, diagnosis of Munchausen by proxy at any time before October 7th, say at Johns Hopkins. And that is the truth.
The question that the court reporter read did not reference Munchausen by proxy.
Your Honor, in the lead up to that question, he had presented the Lee Memorial Health record and Dr. Mendez's record, and the only suspicion in there was Munchausen by proxy. So the question built in that lead up of the Lee Memorial record and Munchausen by proxy, and that was the insinuation.
And not only that, Judge, it is very important to consider here that no
Quick pause. Someone asked a question. Switch sides. Yes, they're going to the microphones. So defense counsel was being addressed, so they took the open mic. And rather than sit on the sideline, plaintiff's counsel walked over to the next open mic, which was in front of the defense table. It was a nice move. It was a nice move, and they've been doing it the entire trial because they want to make sure that it's both heard and on the record. Oh, no, don't do that.
one diagnosed conversion before this. There wasn't a psychologist or psychiatrist that went in and said, I've done a differential diagnosis and this child definitely has conversion. What all of them say is the same thing. Consideration must be given. One of the thoughts is possibilities. It's all like that. And so what the defense has here now is an inability to get that before the jury directly. And the unavoidable conclusion of the jury from listening to the first question and then this one following up is, and it's a technique, I know it, but it confuses and conflates the issues between conversion and Munchausen by proxy. And that is simply not fair and simply not the truth.
Anything else from the defense?
Two things. First of all, David General did in fact say diagnose
Hughes again.
psychological factor affecting physical condition, conversion disorder versus factitious disorder versus other. The folks at Lurie's said something similar about a psychogenic disorder. He didn't say Munchausen by proxy. What I suggest we do is to say that the last question should be disregarded and let's start over. Let's be more clear. That's what needs to happen.
No, this point needs to be made because it's going to come up over and over and over again in this trial. And that is that.
Yes, Mr. Anderson is correct here. For those of you in the chat who are wondering whether I think the judge made the wrong call here. I think the judge made the wrong call. And I think the reason Hughes keeps jumping out of his chair, if you watch him during this, he is up, down, up, down. He is jumping out of his chair. He's the lead counsel. Anderson's right. This issue is going to come up over and over and over again. The hospital wants the diagnosis to be a prior diagnosis. The hospital wants that diagnosis. They need it. They need it. So Anderson's going, no, this is going to keep coming up. I'm going to make my damn point. And he does. He makes the point. And Hughes, you can tell why Hughes, you can tell it's important because Hughes keeps jumping up. The entire trial, every attorney has gone to Hughes to ask questions. This is the first issue where Hughes has popped out of his damn seat and run up to counsel's table and been like, you guys got to make sure you get the right argument. The hospital needs Munchausen by proxy. They need the diagnosis because that's what they justify a lot of their behavior on. So this is a very contentious issue. It's going to be throughout the trial. And this is courtroom theater playing out and how kind of attorneys and judges and lawyers, we can feel where issues are significant. When I first heard this, I was going, this isn't that huge. It's big, but it's not that huge. Then I saw Hughes popping up and going, this is bigger than I thought it was.
That they do not have, and the court just heard, there's a lot of dancing around that, but nobody diagnoses it. Show me where a doctor says after interviewing Maya and after consideration of the record, we have determined, a psychologist or psychiatrist has determined that Maya Kowalski is a diagnosed conversion disorder or a factitious disorder or Munchausen by proxy. It's not.
Side note, that look from the judge, the one where the judge gives Anderson this little side eye, that's not a scolding look. This is a look of kind of admiration of the argument. When a lawyer steps up and says, show me a document, show me a document, show me a document where it says this, that's laying down the gauntlet. That's saying, bring your receipts. And lawyers don't do that to each other unless they absolutely know. So when the judge looks at Anderson here, we changed the little thing that we know we're talking about motions. When the judge looks at Anderson, this is kind of going, all right, you're laying a lot on the line here. Let's let's go.
dancing around that, but nobody diagnoses it. Show me where a doctor says after interviewing Maya and after consideration of the record, we have determined, a psychologist or psychiatrist has determined that Maya Kowalski is a diagnosed conversion disorder or a factitious disorder or Munchausen by proxy. It's not there.
Well, the only thing I would respond to that is if we're saying in this courtroom that only a psychiatrist or psychologist can make this diagnosis, then they had Dr. Chopra come in as pain management and refute the diagnosis. But that aside, it's right here on the Tampa General discharge paperwork done by Dr. Paul Kornberg, who was a pediatric physiatrist.
Physiatrist is your first clue.
Physiatrist, not psychologist or psychiatrist, physiatrist.
3047-0010. I am not inclined at this time to interject myself based on that last question. So
It's the vague
your-
question.
Your request for any sort of instruction with respect to that last question.
I think it was limited to the question. I think the
Certainly,
judge was kind
Don't
of,
want the defense to create an impression, though, that the records don't bear out. So let's just be very cognizant.
Yes, Your Honor.
Well,
I
add that to the
would
motion.
I would have at least admonished the
We're going to get
defense
into it,
lawyer
and I think the
further.
court should enter some form of direction to counsel or order about this. Until they can show it, they shouldn't be coming in here and trying to mislead the jury over this. And that's exactly what's going on.
Anything else?
Not from the defense. Your Honor.
I understand.
Let's bring in the jury.
Can we make sure that this is in the record?
I'll write on it and hand it to the court.
So those were fireworks. Those were fireworks. And it's right. The issue is going to keep coming up. Questionable ruling. I don't know. I felt like it was a little bit more vague than what Kowalski had done. I felt like the question wasn't really that direct. And when you're reading the transcript from an appeals standpoint, it wouldn't have been that clear. I don't know. It was interesting, though. This is going to come up again, though. And the way that Shapiro aimed his cross, this is going to be an issue that we're going to keep litigating. So we're going to see. But we're going to get to jury questions, which, as you guys know, is my favorite time of the day because the jury has so many questions and they're so good. They're so good. This jury is, I love this. I love this. I love seeing this. I love seeing a judge foster the questions and foster the argument. So the jury does great. And we're going into the jury questions. Jury's been the star of this trial so far. Yeah, turn off your phone at 2:20 tomorrow. Okay. Microphone. Mike. Oh no. Oh, the jury's coming in. Why is this muted? There we go.
Okay, please be seated. Members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that correct? And no one approached you about this case. Is that correct? And you have not seen any media coverage. Is that correct? And just to let you know, when you walked out and I turned off the white noise machine, I asked Mr. Kowalski to step outside, so he did not hear me going over the questions with the jurors. So just wanted to let you know. And there's, I will tell you, 9 sheets of paper. 8 pages are full sheets.
9 sheets of paper. That means that either 9 jurors wrote questions or a couple of jurors wrote, well, a couple of jurors wrote 2 pages of questions. 9 sheets of paper. Now the one of them is a half sheet. The judge said, rip off the full damn sheet. So that's that remark, but a lot of questions.
I got 1 page that's not a full sheet. So perhaps in the future, we can just do a full sheet. Okay, Mr. Kowalski. I'm just going to start reading questions. And I will say to the jury, I'm going to be able to ask most of them. There's a couple that I'm not going to be able to, but almost all of them I'm able to ask. Okay. Did you file a legal separation from your wife at the advice of legal counsel to get Maya home?
Glad you brought that up. Yes.
How many of the previous witnesses, how many witnesses has the witness been clearly wanted to talk about something the lawyers avoid and the jury asks the question? Like, how many times has this happened in this trial? This is why I love these questions. The jury literally goes, or the lawyers avoid the question entirely, don't give the witness the opportunity to answer. And the jury's like, let me ask you that one question you've been wanting to elaborate on. And the judge is like, here you go. Here you go.
It was advised by the child's attorney to get a legal separation. That way Maya could come home and be out of the hospital. But, oh, I'm sorry, it wasn't the children's attorney. It was one of Beata's or mine. And the child's attorney advised not to, because the problem there, now mom wouldn't see Kyle. She wouldn't have no kids to see. But she agreed to move out of the house to have that happen. But it was the advice of the children's attorney not to do that, because now she would be without Kyle.
When you checked into the hospital, did the hospital registration explain your rights and responsibilities, or just ask you to sign the consent form?
It was more of signing. Maya was in severe pain. There was no, they didn't explain anything at that time.
And there's a question on that sheet that I'm not going to be able to ask that last question. Mr. Kowalski, this is in regards to the hospital, or the hospital wanted passwords of Maya's social media accounts. Was this requested verbally or in writing?
They called me.
Do you recall who requested a name, a known name?
I do have it. I believe it was Child Life that wanted it, and they stated that they wanted to set up a computer for Skype. But Maya had her own computer there already, so I didn't understand why they couldn't use that one. But they wanted Maya's passwords for all her social media and that. And my recommendation was to just go ahead and use a new password and just give it to us. That'd be a lot easier.
Well, I think you were anticipating the next question. Were passwords given to the hospital?
No,
Okay. Also, was Maya allowed to use social media while in the care of the hospital?
no, she was allowed to use a computer for school. This, I think Jackie Dieter mentioned that. It was the first time the school did something like that, Skype. And then it was probably a good thing for them, a good test, because not too much longer COVID was here and everybody was learning from home. But
Did the hospital keep Maya from communicating or posting via social media?
I do not believe she did any social media there at that time. That I honestly couldn't answer that one fully.
All right, I want to make a caveat here, a quick question or a quick comment. There were a lot of remarks about whether his testimony was believable. Same with prior witnesses and the credibility of the witnesses. What I want you to listen to is the level of detail he goes into in his explanations, and I want you to remember the physical therapist, the UF, the University of Florida, the lacrosse player, that one, and the question that she was dying to answer from the jury. And I think she scored more points in credibility with the jury questions than she did with either question from attorney from the plaintiff or the defense. And I want you to think about that with Jack. The jury is getting to assess his answers, and there's no one cutting him off. And he gives more information that's more detailed in his responses to these open-ended questions than his attorney allowed him to do. And that's for various reasons, but I think the jury gets a different measure of the witness when they're answering their questions versus when they're asking questions from the plaintiff or the defense. I think the jury is viewing these questions more significantly than the ones that are being asked by the attorneys, which are trying to point the witness in a direction one way or the other.
Okay. The same juror, the next page, I'm not going to be able to ask those questions. Maya was discharged with 3 to 4 diagnoses by Johns Hopkins All Children's Hospital, and none were CRPS. Is that correct?
That is correct.
Next question. When, if
good
at
point.
all, was Maya ever examined and given a diagnosis of CRPS? The date and the doctor name, please.
That was Dr. Anthony Kirkpatrick in Tampa, and that was after the Tampa General. So I would say, I'm guessing around August. I could be wrong on the date or the month.
Okay. The next series of questions. You are stating that the detective, after identifying herself and you agreeing to be interviewed, did not, 1, place a recording device in plain view, like on the table you were sitting at. I guess, is that correct?
That is correct. It was not in view.
Anyone else pick that up? There's some of the jury that did. Chat, you guys are broadcasting everything else. This question was like, oh my God, someone on this jury knows a whole lot about law enforcement interaction. Oh, baby. You think that officer's testimony is going to be subject to question? This was a good one. This was a good question. And the follow-up's even better.
Is it correct that she did not ask if she can record the interview?
That is correct. She did not.
Is it correct? She did not start recording and first on the record, identify herself, title, the date, time, location, and your name as being interviewed.
I didn't hear that.
It's former law enforcement. That's got to be.
Thank you. Now we're going to the next juror's
Or
questions.
a spouse of law enforcement.
I have to say, I appreciate y'all have much better handwriting than me, but my handwriting is horrible. So at least I'm able to read y'all's. So thank you. When you testified that Maya was not having withdrawal, how would pain reaction differ from withdrawal?
What I believe the question was with the withdrawal that was from the medication. She did have pain though. She was always in pain. And like I said, it's not a constant level of pain. It could be high and it could be low. But when we were discussing withdrawal, that was in reference to ketamine. I never seen a withdrawal from ketamine.
What did you observe that helped you know the complaints were pain versus withdrawal?
Her complaints?
Yes, her being Maya's complaints.
The pain, you could see her guard, and then, her facial expressions. A withdrawal, I would imagine more shaking, things like that, like I don't know, seizure but you could see the pain. And I know her pain, so I knew the difference, and I never witnessed a withdrawal.
Next question. When Maya had her issues on July 4th, it seems that lack of motor function and pain reaction seems like a significant development. The record showed treatment took place a few days later. When did pain climax on July 4th?
She had pain, and they first believed it was from all the steroids she received. But then later in July, I believe, July 20th, that's when we really started seeing more signs with the pain.
Again, you contemplated the next question.
Good at it.
How long between episode to ER treatment?
I believe there's one before the 17th, but there was one in between, I believe. I could be wrong, but I'm almost positive. But we see more pain and more problems as it went on.
If there was a delay of more than a couple hours, why?
I don't understand that one.
Okay. I'm sure the lawyers can follow up. Maya's room, when it moved, did Maya get moved often? If so, how often?
Maya did get moved, and I read in my notes just recently, she asked that question, and the nurse stated after 30 days, you get moved to another room. I don't know if that's true or not, but I just read that today in my notes.
How many floors was she moved to during her stay?
I know she went from the first floor, and then the main, most of the time was on the 7th floor. I could be wrong. There could be another floor involved. I honestly do not remember, but all the moves to rooms was basically on the one floor of, I believe it was 7th.
And did Miss Beatty follow her through the floors?
Yes, she did.
Next question, and for the juror, I'm not going to be able to ask that next question on your list, but the following one, in your experience as a fire expert, are parents usually a trustworthy source of information during an emergency or a hindrance to EMT assessment?
This
We
was one
utilize the
defense
people as
didn't
much as
want to ask.
possible. If they were, there's great resource, medical, and then also fire incidents. If you have somebody in a building trapped or whatever, they may tell you exactly where they're at and how to get in there. It'd save a lot of time. We don't have this where like a football team where you could take a timeout and figure everything out. You try to get information right away and act on it. They could be a problem too, where they're trying to tell you everything to do. And as a manager, all the fire officers went through a lot of management classes. They could be a great resource or they could be a problem. And if they're a problem, you should just kind of remove them from the area so you could do your job.
Did Beata supply dosage information to her blog?
That I don't know. I never really followed the blog.
Okay. How frequently was she updating it?
That I don't know.
So you wouldn't be able to know how specific?
No, sir.
Okay. Or a police source?
What's
It just says police source.
police source?
Yeah.
I honestly don't understand that.
Had you met the officer who investigated the suicide prior to the suicide?
No.
Okay. Was the local quote force end quote aware of your career?
I'm sure they were. Yeah, they do ask you your occupation and everything. In the garage, I do have my old fire code in there, so I'm sure they've seen that. But I believe they do ask you what your occupation was.
Next question. You stated you did not want your daughter to take opioids. did you request alternative medicine the first time the opioids were prescribed?
I don't know when the first opiates were prescribed, but we looked at the hyperbaric treatment, and that was without any medication. We thought that would be a good route to go. Unfortunately, it was out of pocket, but at that point, we didn't really care. We cared about Maya more than anything. And I'm meant to ask the doctor about if that helps the liver too, but I'll have to find that out someday.
I'm going to go ahead and ask this, although I wasn't quite sure if, based on your answer, but if the previous answer was yes, what were the options and why did you decide against the alternative medicine?
Yeah, I wasn't the one doing most of the research, but I really don't have an answer for that one.
You stated most communication went through Beata.
That is correct.
Would you read through the medical notes throughout the duration of Maya's illness to ensure you received accurate information and to ensure that there was a clear understanding of communication between Beata and the medical staff?
I did not review them in full. She would let me know. She dummied it down for me. I do not know a lot of these terms or treatments, but I had 100% trust in her.
If your brother was not approved for visitation at Johns Hopkins All Children's Hospital, how was he able to drive Maya to the Sarasota courthouse for Dr. Duncan's evaluation?
I'm from a family of 8. It was my other brother that drove Maya to the hospital or the courthouse. It was not Bob. That was through the court.
During the time of the surveillance video at Johns Hopkins, do you know if medical orders were placed that required Maya to have assistance getting out of bed because of safety concerns?
I'm unaware of that.
Good question.
Page 8. At any time has Johns Hopkins All Children's Hospital staff, and I guess this is if you know, at any time has Johns Hopkins All Children's Hospital staff been trained on CRPS, how to treat, and when did that training take place?
That I do not know.
Question.
And for this juror, I cannot ask the next question. The next question, Kathy Beatty, does Kathy Beatty work at Johns Hopkins All Children's Hospital or CPS or DCF? And is she still working there?
I believe she was an employee of the hospital and she's no longer working there.
And the last page, the page that isn't the full page. It's missing its friend. Okay. Was an assessment or investigation ever conducted on the family to either confirm or rule out the Munchausen allegation?
Big question.
All family members, we
Big
had to go
answer.
for a forensic psych evaluation. That was through Dr. Duncan. And I believe that's what they were trying to use that to rule it out. And I believe we heard Dr. Duncan with her findings.
And then the next question is, if so, by who?
Dr. Duncan.
Okay. Members of the jury, that concludes the questions that were given to me. We're at 5:25. I see we've got one more. Let me ask you this. I'm sure the plaintiffs and the defense are going to have follow-up questions. We're at 5:25.
So we're going to end it here. We're going to end it here because I wanted to cover that. The jury is listening. They want the information. They want the information and they are listening. That last question was very significant because it was basically saying, was a family ever evaluated? And it was, yes, Dr. Duncan. And Dr. Duncan had said that the family wasn't a risk. So I like this trial, man. It's a good trial. It's hard. It's difficult to cover. The subject matter is very difficult and complex. It's difficult to break down some of the arguments, but I like this trial and I like this judge and I like this jury. We're going to have to see where this goes because there's a whole lot to be developed. Let me catch up on super chats. And then we will wrap up and get out of here because I have a 9 a.m. hearing. Okay. Here for years. Rob, it's been a month. How's the new job? New job's great. Like I said, hearing tomorrow. Can't wait. And hearing on Thursday. The trial next week. So love it. Leader Randolph, my apologies. Rob, is it just me or do you think the jurors ask good questions? You know my answer to that. They ask great questions. M169, thank you. Having a kid with a complex medical condition or disability you never saw coming is extremely taxing on a marriage. It takes extra work and communication. I would say that it absolutely does. And that was the comment I was making there. Charlotte, thank you. No mandated reporter would wait for a previous diagnosis. That's correct. And the judge has ruled on that. The report itself, the phone call itself, can't question the phone call being made. Reports are based on good faith suspicion. Failure to report can be a crime. Exactly. And that's the nuance that we're balancing with this trial and why I like explaining it, because for everyone that says they must report everything, for everything that says they can't report anything, there's a slope, very slippery. It's where do we draw the line on that slope? But Charlotte makes a very good point. And the phone call to DCF isn't the problem. That's not the problem. The judge has ruled that you can't question that. It's all the predicate that led to that. That's the question for the jury. Mary Coppola, thanks again, Rob. Good luck tomorrow. Thank you. Ms. Pete, glad to see you back in the chat. Love seeing you here. They keep saying diagnosis for Maya is Munchausen by proxy. That's what the DAG diagnosed for mother. Munchausen would be Maya's diagnosis. Why is that on our transfer orders? I'm confused. We are all kind of confused, and we're starting to get the dots connected. It's still early in the trial, day 8 of an 8-week trial. So we'll see how well we do tomorrow. Equality, thank you. So glad the jury is the jury. Me too. Shiraz, thank you. Does anyone know if there are caps on what juries can award money for malpractice? They have sued for $200 million, and we'll see what happens. Carla Riley, thanks for being a member. This trial is fascinating. Thanks, Rob. Thanks, you. Thank you very much, Carla. Emma, thank you for the super sticker. I do want to shout out that there were a lot of gifted memberships this evening, and you guys have been really, really, really generous with that. Katja the Frankenfurter, thank you for the gifted memberships. Fiona W. for the gifted memberships. Jess Rubery, gifted memberships. E. Warner, gifted memberships. Lori Liani, gifted memberships. Baby Gator, gifted memberships. Equality, gifted memberships. Cachette, gifted memberships. Carla Riley, gifted memberships. My mods are sending me a note. That's 136 gifted memberships this evening. You guys are incredibly generous and kind. I know I promised releasing a video for the members only. I'm still working on that. It's in my editing software. I just have to trim it down. I just need like a minute, like a spare couple of minutes to do that. So you guys are incredibly generous, and honestly, it's amazing to have you guys here for the recaps. I love doing them. It's taxing, but it's important. So thank you guys very much. To those of you who are still watching or have watched or tuned in, please remember to like the stream. It does do a great deal for the channel and for people that are trying to find this particular type of coverage. So I don't know what else to say. If you guys want to be a subscriber and you want to keep getting these recaps, please do so. Hit the notification button, the little bell there, and it'll tell you when we're going live. I try to keep it around 8 p.m. I'm going to see if I can keep doing that. It's a challenge. You guys complain about 1.5 speed. I'm on like 2x, and sometimes downloading it and trying to listen on 3 or 4x because I've got to catch up with the day in court and out of court doing law stuff. But again, I appreciate you guys doing this. I am streaming tomorrow, but it's not going to be Trials of the Century. It'll be a recap. Ian is out on a hunting expedition, so Trials of the Century will be next week, not this week, next week. So tomorrow will be another recap of the Maya Kowalski trial. That's just an announcement, likely at 8 p.m. And hope to see a bunch of you here. So without further ado, I wish you all a very pleasant evening, a very happy Wednesday as you begin the day tomorrow. And I hope to see you guys here tomorrow evening. So thank you guys. See you then.